So first of all, you have to choose your trademark. There are so many considerations when choosing a trademark, right? And some of these considerations will usually come to fore during the examination of that trademark when you have actually filed it for registration. And in choosing a trademark, usually there are 5 categories of trademark, you know, the way we know it. At the apex, you have the fanciful trademarks, you have the arbitrary trademarks, you have the suggestive trademarks, descriptive, and then the generic ones. The fanciful, the arbitrary are usually the highest. They are the ones usually called distinctive trademarks, usually invented words that you can, you know, for fanciful trademark, invented words that you've not seen or probably heard anywhere, you can't find in the dictionary most times. So the company just came up with it. A name like Indomie is a fanciful trademark, right? Some without the company, you would have not known any word like Indomie. You have the arbitrary trademarks like Apple, which is a word you know, and it has a meaning for something, but in the use of that word as a trademark, it has a totally different meaning. So using Apple for fruits as a trademark, it's an arbitrary trademark and it's considered a very distinctive mark. You also have the suggestive marks that, you know, you can actually say that they are distinctive, but once you mention that name, if I hear the name or if you hear the name, you'll be able to link, even without knowing what that trademark is for, you'll be able to have a connection to link that trademark to the kind of services or the kind of goods you will get. So something like Netflix, when you hear it, you know, have that kind of feeling that it has to do with the internet. If you hear Airbus, you know, you have the kind of feeling that this has to do with transportation via air, just by the name. Then at the lower level, you now have the descriptive marks, which are marks that normally describe the nature of the product, or you can just say that it qualifies the product or services that you're using it for. So when you say rich milk, for example, as your trademark, that rich there will probably be considered you're trying to describe the quality or nature of the milk you're selling. So, and then the last one is the generic marks, the names that are general for that particular goods or services that you cannot have an exclusive right over. Something like trying to register computer as a trademark for laptops, you know. So at that lower level, the 2 lower ones are the ones that will usually not fly when you file for the registration. That will come to examination later on. So when you've, you know, picked a trademark, you choose what chosen the trademark you want to use, the law allows you to ask for an advice from the Registrar of Trademarks, right? A lot of people don't do this in practice, but it's there in the law. You can ask the registrar via an application, you make a payment and say, okay, this is the trademark. Do you consider this trademark distinctive enough for registration? And the registrar can give an opinion, yes or no. And if he says yes and you file the trademark and later on the examiner refuses it and say this trademark is not distinctive, you can go and claim your money back from for this advice, right? But I know in practice a lot of people don't do this, but at least it's there in the law. Now, when you file your trademark, or before you file your trademark, it's advisable before you file, you do the search. We call it availability search in Nigeria. Some other places, they call it the clearance search. So you do a search to know if there is a trademark that is already existing on the register, that has been registered by somebody else that is similar to that one you want to register. Now, why this is important is because if you go ahead to register, it may be refused. That former trademark may be cited against your own for the similarity and it will be refused. Or even if it escapes that examination stage, during the opposition period, the owner of the prior trademark can come after you, can oppose your own by saying, I have a trademark that is similar to this one you want to register, and I registered before you, so your own cannot proceed to registration. So assuming you do the clearance search and they say the name is free, it's fine in that particular class, go ahead and register. You make your application. At our registry, you can apply online, you can do the manual application. Either way, people prefer the online application because probably it's faster. Manual has some issues, at some point they can tell you that the physical file is missing and all those things, right? So you can do the application online manual, you get your acknowledgement form immediately you apply. Then once you apply by doing the registration and you've gotten your acknowledgement form, the staff at the registry will start their duty. The first one is they will do a search on prior application. So that search you did before you filed, the officers will still do it after you have filed to be sure that there is an existing trademark that is in that class that you file. Where we have 45 classes of trademarks that you can, 45 classes of goods and services where you can file your trademarks. So you have to file your trademark in one or two of those classes. So when you file, let's say you file in class 5 for medical, pharmaceuticals, and then they will have to conduct a search in that class 5 to be sure that there is no exactly that mark or a similar mark in that class before now. I know there are issues with this. We won't dwell on that because sometimes you will be sure that there is a mark that is existing, and then the officer that conducted the search will come up and say there is nothing existing. There are obviously limitations, but at least that's the procedure, they do it. So, and if they see any trademark that is similar to the one you want to register, they will flag it. The officer will flag it and say it's similar to this and this and that, and then we'll send it to the examiner. Now, when it comes to the examination stage, the examiner will be looking at the distinctiveness of your trademark. Remember the 5 categories I talked about. So this is the point where if you are filing a trademark for a trademark that will ordinarily fall under the descriptive class or the generic class, here is the place the examiner will have to refuse your trademark and say, this trademark is not distinctive. This trademark is this or that, it's merely descriptive. You can see some refusal letters like that. Then again, if the search officer identified any similar trademark and sent it to the examiner, this is also the point where the examiner will say, I am refusing this trademark because it is similar to so and so trademark that was registered in 2010 or 2005 or 1998. They will write it there and issue the applicant a refusal letter. But assuming everything is fine, the mark is good, there is no cited prior resisting mark against it, the officer will issue you an acceptance letter. Once that is done, you will now wait for when the trademark registry will publish a journal, a very big booklet of applications that are filed over time. Now, when these journals are published, every interested person, any third party, has a time frame of 2 months between the date of publication and 2 months after to file an opposition against any trademark. So if a trademark journal is published on January 1, you will have till the last day in February to file an opposition. And the reasons, we'll get into that later on, is if you think the mark is similar to your own, if you think you are the owner of this mark, even though you've not registered it in Nigeria, but you're the owner of this mark worldwide, for any reason you want to, you will file your opposition, and that is where and once you file the opposition, the trademark registration process for that application will stop at that point. We'll now move into opposition. It's until when the opposition is done, when you are done and probably the applicant emerges the winner, then he can come back to do the remaining steps on the slide. So let's assume there is no opposition. The next step will be, after that 2 months for opposition and nobody's opposing your trademark, you will now move to the clearing point. All those ones are the internal mechanisms at the registry. So they will clear your application. They have a way they clear it. They will mark those that have been opposed, they will remove them one side. The ones that are free, they will clear them for the issuance of registration certificate. Then you, the applicant, you will now go and pay for your registration certificate, and then the registry will issue, they will print it, the registry will seal it, sign it, and you will be issued a certificate. Now, it's important to understand this process because I needed to make this point. Most applicants confused. They don't understand the entire process of trademark registration. Most people usually stop at the acceptance stage. And even the court made a mistake in one judgment, D&S matter against Remia. They made a mistake by saying that the acceptance letter is an equivalent of a registration certificate. So you see the entire process of trademark registration. So there's no way acceptance stage, when you have gotten your acceptance letter, will be the end of the process. In fact, if your mark has been accepted and you fail during opposition, let's say a third party opposed and you fail, that acceptance letter will be withdrawn and cancelled. So you have nothing again. And why people tend to make this mistake is, for example, if you want to register a product with NAFDAC, they will usually require evidence of trademark registration. Because NAFDAC understands that trademark registration could take forever to be concluded, they won't force you to wait till you have gotten your registration, which may take years. So they will allow you to get, if you get an acceptance letter and present to them, that is fine. They will accept it and they will go ahead with your NAFDAC registration. So this is usually where the problem comes in. When people now get an acceptance letter for that cosmetics they want to import or produce in Nigeria, for that food product, biscuits, sweets, drinks, sachet water, bottled water, anything. Once they get the acceptance letter, they rush, do their NAFDAC registration, and they forget about the trademark process. We've had so many applications for pharmaceutical products, for bottled water, drinks, and so on and so forth, that when they got to the opposition unit, the applicant will lose and the acceptance letter will be cancelled. But the person will still be wherever he is, holding on to the acceptance letter, thinking that he has a trademark registration, not knowing that everything, the application that he made has been abandoned and cancelled. So that's why it's usually fine for you to process, even if you've done whatever you want to do with the trademark, with NAFDAC or whatever, it's always necessary to process it to the end before you can validly say you have a certificate, you have a trademark registered in Nigeria. So that's for the process itself. Now, we'll now go into the opposition procedure itself. So remember, when the trademark has been published in a journal, you can say when it has been advertised in a journal, the advertisement in a journal is like a notice to the world to say people are now claiming exclusive rights to these words or this slogan or these logos or colors or whatever it is. Do you have any objection? So the registry is, the trademark registry is by this notice inviting people to come and object to the registration of any of the trademarks that are published. If you see a journal, it has thousands of applications in it. Now, what brands do, let's say, for example, Coca-Cola, for example, what they do is brands that are very serious with protecting their trademarks, they will usually have agents, either they are the lawyers working for them or their in-house staff or anything, or all these third-party watch service companies. They will usually have agents that will be looking at every journal that is published to be sure that there is no mark that resembles, that is similar to their own, that will fly through to registration. So sometimes you can go to that your class of interest. Let's say Coca-Cola, for example, their class of interest probably be like class 32 for the class for drinks and the rest. If they will go through to be looked at the trademarks advertised one after the other. So if somebody wants to advertise, register, for example, Tola Cola, they will say this one is similar to our own, we have to register. Or if we have people like that, somebody even wants to register Coca-Cola itself, they will flag it. Now, when you have seen an application you want to oppose, you don't want this one to go to registration, what do? You file a notice of opposition within that 2 months period. That 2 months period is non-extendable. It's a provision of a statute, and we know the principle that when a statute, this time around, it's not a practice direction or or what's it called, rule of court. When a statute prescribes the time for doing an act, it cannot be extended, because there are instances where some clients will be like, oh, I missed the period. Can we still ask for extension? Can they, condone us, this and that? You say it is non-extendable. It expires at the 2 months, and that's all. The only thing that can make it is if the last day of that 2 months is probably a Saturday or a Sunday or a public holiday, then you know, of course, by the Interpretation Act, the next working day will be the deadline. So if you want to oppose a mark, you file your Form 6, Notice of Opposition. You list out why you are opposing the mark. You state your name, you state your address, you state the name of the mark. For it, the person's address, the person's agent, then you give your reasons why you're opposing this mark. If you have a registered mark before now, you stated there that you're opposing this mark because you have a registered mark which is similar to the one this person is trying to register. If you have an unregistered mark, I remember yesterday someone asked that question to my colleague, China Sawana, whether if you have an unregistered mark, you can enforce it against somebody that wants to register in Nigeria. It's done, even in opposition. Even if you don't have, even if you're not registered in Nigeria, but you feel that this trademark belongs to you, you've been using it in the US, in the UK, everywhere, and people know you, and then this person wants to register it in Nigeria, you can oppose and say why you are opposing. So when you find notice of opposition, it's usually to state, after stating the parties and the application you're opposing, you state the grounds why you are opposing that trademark application. When you've given your grounds, you submit the notice of opposition at the registry, trademark registry, you pay for it. Trademark registry will do their own internal process. They will issue what we'll call Form A. And then when you've sent that notice of opposition, in that journal, they will now mark out that application you are opposing. They will mark it off and say this one has been opposed. So we are not going to clear it for certificate, at least for now. Let the opposition process be concluded first. They will mark it out. Then they will issue what they call Form A, which is just like a cover form they will use to serve that notice of opposition on that applicant. So the applicant will be in the office, they will send it, and the applicant will say, oh, the application I have filed has been opposed. And what would the applicant or his lawyer do? They will now file a counter statement. The counter statement is just slightly similar to opposition. You will state the parties as well, state the grounds why you filed that your application in the first place. So remember, the person opposing will state the grounds why he's opposing you. You will state the grounds why you filed that application, why you believe you have a right to that application. So you either say, oh, I've been using it before, or I inherited it from my former company, whatever reason, you will state it in your counter statement and give it to, and will also file it at the registry. You make your payment. The registry will also serve it on the opponent. And you do that within 1 month when you've received your notice of opposition. These 2 periods are non-extendable. The other processes, you can extend the time, but this particular 2, these 2 months for opposition, 1 month for counter statement, you cannot extend the time for it. Now, when you have served your counter statement, when the trademark registry has served your counter statement on the opponent will now file what we call statutory declaration. The act, the regulation calls it, you file your evidence by way of statutory declaration. So in the notice of opposition, you're just giving the grounds. But in the statutory declaration, this is where you are now giving the evidence of those things you stated in your notice of opposition. So for example, your notice of opposition, if you said you have a prior mark in your statutory declaration, you will now annex your registration certificate to say, this is the proof of my prior mark. In your notice of opposition, if you said This your mark is well known all over the world. Hey, they've ranked you #1 in Australia. They ranked your company #2 in Jamaica. You get this, the screenshot or the journal, the magazine, or anything that did all those ranking. You put all of them in your counter statement. So this is where you pack all your evidence and bring to the registrar. They will serve it on the other party as well. The other party will have also 1 month to respond to you. The time for doing any of these ones can be extended if you feel 1 month is not enough for you to gather all the evidence. Sometimes some clients do have that difficulty. All these multinationals, okay, this lawyer is working for you in China and you needed to get evidence from all over the places, and you say 1 month is not enough, you can apply for extension of time. The registry will give you an additional 1 month to compile. So when you have compiled everything, file, it will be served on the applicant. The applicant will compile his own evidence to serve on you. Now, when the opponent receives the applicant's evidence, the opponent has a right, it's not compulsory, but they usually do, to also reply. If you have some points the applicants have raised in their own evidence and you want to debunk it with another evidence, you do so. You file it in your reply statutory declaration, file it at the registry will serve it on the applicant. Now, when these 5 documents have been filed and exchanged between the parties, the registry will usually, they have an opposition unit at the registry. They have a court setting, where they hear all these things, and they have staff members that are dedicated for opposition. So when you have done all those things, the officer that's in charge of that matter will now invite you all, the 2 parties, to say, okay, let's settle records. Let's see what have been filed. You filed this, you filed this, you filed this, everything. Everybody confirms that they've been exchanged all those processes. Now we are ready for hearing. The officer will now say, opponent, you have 2 weeks from today to file your written address, your arguments in support of your case. File it, serve it on the other person before 30th of March. The other person, that's the applicant, you have 2 weeks also from the date the opponent serves you the written address to file your own written address. File it, serve it on the opponent between so period. Opponent, if you have any reply, you reply within 1 week, serve on the other party, then you people will come back for the hearing or adoption of addresses on a particular day. Then the opponent will go back, you will draft your written address, just the same way it's done in court. You make your arguments why the applicant's application should not proceed to registration. Cite all the cases, authorities, put all of them there, and you file and serve on the applicant. The applicant will do their own as well, file their arguments, the authorities in support, the decisions of court, serve on the applicant. If applicant wants to reply on points of law, not just to raise issues again, but to reply to the applicant-specific arguments, the opponents can reply, file it, serve it on the other person. Then both parties will come back on the date the officer that is in charge of the matter gave to them. They will come back and then they will argue their matter. Most times the officers, because of time or wanting, they may not allow you people to do an elaborate argument, right? They will just say, adopt your written address, I will go back and read. Of course, the same way they do in court. But if there is time, they can allow you to argue. But most times they don't allow, oral arguments. You just adopt. The officer will go back, read the whole thing, consider the evidence you people filed, consider the arguments on law, the cited cases, and then write a ruling. When the ruling is ready, both parties will be invited as well. The ruling will be delivered. Say it can only be 2 things. This application is, the opponent has succeeded in proving that this application is similar to his own, or the opponents have succeeded in proving that he has a right to stop this application. Probably is similar to his own, or he's even the owner of the mark itself, or whatever reason. That's if the opponent should win. Then if the applicant is the winner, it then means that the officer found out that, the applications are not similar. The consumers cannot be confused. This one is Indomie, this one is Indo time. They are not the same. I don't think anybody will be confused. Both of you should go and be using your marks. That means the applicant has won. So if the applicant wins the opposition, then the application will be allowed to proceed to the remaining registration process, which is up to the issuance of registration certificate. But if the applicant lost and the opponent won the opposition, that is the end of that application. The order the tribunal will usually make is to say the acceptance letter that was issued initially has now been cancelled and withdrawn. So remember, they've given the applicant an acceptance letter, but at the end of this opposition, that acceptance letter is now cancelled and withdrawn. They will not tell you to bring it back. That's where the issue is. They won't tell you to bring it back. So that's why the applicant can say be carrying the letter around, claiming or maybe even using it as evidence that he has a trademark registration, not knowing that it has been cancelled. Now, sometimes an opposition may not run through all this process. If it happens a lot of times, if it is undefended, most times when you file your notice of opposition and you serve on the applicant, it's either the applicant is no longer at the address they use. It's just like people incorporating companies at CAC, they just use any address, not knowing that it will have effect later. So this one you can just use, tell the person that is filing for you, I beg, use your address. The person uses this address. Tomorrow, the person is no longer at that address. When the registry now serves the notice of opposition to that address, nobody will be found or the applicant won't be found. The next thing is they will abandon your application. So sometimes the opposition can be undefended and the opponents will just win. The application will be cancelled, while the other party will still be holding on to the acceptance letter, thinking he has something. It has happened in an ongoing matter at the Federal High Court now, involving two big companies. The other one sued the other one for infringement, and the guy said, I have a trademark for this, so I have show us proof. He brought out acceptance letter. The other one said this acceptance letter has been since cancelled since 2010 when we won your opposition undefended, and issues started arising from that scenario. So that's it for opposition procedure. Then there is opportunity for appeal. Whoever that win or that won the process or lost can, appeal at the Federal High Court. Appeals from opposition tribunal, that's everything at the registry, lies to the Federal High Court. So you can appeal the decision, and then from there, you guys can move all the way to the Supreme Court. Now we'll move to the last part of the discussion, where I call the knotty issues. So usually, IP lawyers, we know the way we run things and do things, but it's been discovered that when you get an opposition document these days, a lot of arguments that probably you will say this one is new, or this person doesn't understand the process, or this and that. So many arguments keep coming up on several issues, and I won't take it in the order it's arranged there. The one that is most common these days is the argument on similar question someone asked yesterday, whether if an opponent does not have a registered trademark, can that opponent oppose another person's application? That is one argument that will always come up. Not always, but most times do come up. And this thing usually happens where a foreign company or these multinationals that are well known, you'll be surprised to know that some of these companies that you hear of their brand names, they don't have it registered in Nigeria. It's only when they fall into issues such as all this opposition or infringement action that they will not consider registration. But because they believe that everybody knows them all over the world, so you can't really steal their trademark. But they don't know that there are some people in Nigeria that are specialized in stealing other people's trademarks. So that argument has always been, if you don't have a registered trademark, some people will say you cannot oppose another person's application. And they will usually cite Section 3 of the Trademarks Act. Now, Section 3 of the Trademarks Act says if you don't have a registered trademark, you cannot sue for infringement. It did not say you cannot oppose an application. It says you cannot sue for infringement at the Federal High Court. And it also reserves the right of a person that does not even have a registration to say, even though you cannot sue for infringement, but you can still sue for passing off. So some lawyers or some agents will now draw that argument into an opposition process to say you cannot oppose when you don't have a registration. Now, my opinion, all the things we are going to talk about under this subtopic, not issues, they are all my opinion. I will tell you what is in the law and then what I think of it. My opinion is that that argument is not correct. The section 3 that some agents will rely on specifically say you cannot sue for infringement. So you can't interpret it beyond what the statute has said. You can't say, you can't take you cannot sue for infringement to be an equivalent of you cannot oppose another trademark, right? Now, importantly, section 20, which provides for this opposition procedure, says you can file your opposition within 2 months on any ground. It didn't limit the grounds that you can use as a reason. That is one point. It didn't also limit the kind of person or the number of persons that can oppose a mark. Now, why this interpretation is good for us to draw this analysis. If you look at other provisions of the Act that has 1 or 2 things to do with contentious issues such like opposition, if you look at section 38 that made provisions for rectification action, it says any interested party who alleges blah, blah, blah will do so under these 4 grounds. It listed 4 grounds that you can do, you can request for rectification or cancellation of someone else's trademark. It's either that the mark was wrongly registered, it wrongly remains on the register, the person registered it without sufficient cause or whatever. There are just 4 grounds. And he said any interested party. So you must have an interest in that trademark that you want the registry or the court to cancel. The same thing under section 40. If you as the proprietor wants to rectify or adjust, 1 or 2 things in your trademark, in your own application, there are reasons for doing that. But when it comes to opposition, he just said any grounds. He didn't limit the grounds of your opposition to section 3, like some people will argue, or even ownership of a trademark. It doesn't say you must own a trademark for you to oppose. Now, for the other side of the argument, which is I don't have a trademark registered, but I am the owner of this trademark all over the world, where you can Section 18 of the Trademark Act, only a true proprietor of a trademark has the right to register it. That's not the way it is, but that's the interpretation. A proprietor of a trademark having interest to register, you have to bring an application, blah, blah, blah. So the interpretation is you that is the true proprietor, the owner of the trademark, you are the one that's expected to file of that trademark and not any other third party, right? So if you are the owner of, let's say, Lolade is your trademark, and you are the owner from US, you've been using it all over the world, even people in Nigeria. Of course, internet age, people, you can even see products that are advertised on Alibaba, on Amazon, and the rest of them. People even order and get products from abroad into Nigeria. So it's common for you to see or know the brands that are used in the US or other countries. So now your trademark is Lolade, and then somebody in Nigeria now wants to register it. The person has filed for the registration. One of your grounds of for opposition as an opponent could be that this person is not the true proprietor of this mark, because I am the one that developed this mark. You can even give history. Some of these marks you see have meaning. Some are either the names of the founder of the company, some are either, an abbreviation they coined out from their family name or this and that. So you trace, you say, this is how I came about this mark. This is how this is not just something I just this is how I developed it. I am the true owner of this mark. So this person that wants to register it cannot be allowed to register it because he does not have a valid right to the ownership of this mark, even though he's trying to do the registration, of course, because the general rule is that in Nigeria is the first to file jurisdiction. So that's why people usually rush to go and register, so that some actually do it as business, bad business actually. They will register and tie it down so that whenever the true owner wants to come and use it, they will not tell you to come and settle him before he can release your trademark. So that's what we call bad faith registration. We have a lot of them, bad faith registration. You will see a trademark that is doing well abroad, you register it in Nigeria and just hold on to it, waiting for the owner to come so that you start fighting the person and start collecting money. So that's for the grounds of opposition. The two remaining points, service of opposition processes in Nigeria has become a big issue. I mentioned one of it already. When you go to serve and the person is no longer at that address and the rest of them, it may interest you to know that, of course, our Trademark Act is very old, and even the regulation very old. There is no provision for e-service that some courts have adopted now, that you can serve somebody via WhatsApp or email or this and that. We don't have provisions for all that. So service remains a problem. That's why sometimes if you do a default opposition, sometimes the registry, they are too reluctant to issue an abandonment, because they'll be like, what if this person has moved from the address? What if he changed the agent and then they will abandon now? The person will now come tomorrow and start shouting, why did you abandon my trademark? So it's also an issue in opposition process. They try to be very careful these days before they issue abandonment notices for, lack of service, maybe for issue of address and the rest of them. And then that's statutory declaration that we talked about, the evidence. It's usually in the form of an affidavit, exactly the same format. I, so and so, Christian, this, that of so and so address, do hereby you state all the things you want to state, and you sign, you depose to it before a notary public or a commissioner of oaths. Now, the argument now became, I've seen some opposition documents where we have rules of affidavit under the Evidence Act. They say you cannot do legal conclusion, you cannot make arguments, this and that in an affidavit. But in a statutory declaration, you can do all those things. You can argue the way you want to argue. You can conclude on anyhow you want to conclude. The issue now became, some will raise it, that this person is doing legal conclusion, this person is making an argument in a statutory declaration, therefore the tribunal should strike out paragraph this, and that. And when you see, you'll be like, this has been the format now. Who is bringing the rules of affidavit into statutory declaration? So the point is that these two things, even though they are almost similar, they are not the same. A statutory declaration is totally different from an affidavit, and the provisions of the Evidence Act regarding affidavits, the rules guiding affidavit does not apply to statutory declaration. So you're free to do your arguments, do your conclusions, and whatever you want to do in a statutory declaration. The provision of the regulation or the act that made provision for that did not say that the rules of affidavit under the Evidence Act will apply to a statutory declaration. So that's try to cover up the major issues within the allotted time, and open to your questions at this point.
All right, thank you so much, sir. I really appreciate you for taking us through the nitty-gritty of registration of trademarks in Nigeria. Please kindly confirm you can hear me, please.
Yeah, I can hear you.
All right, so really thank you so much for taking us through the nitty-gritty. So in case anyone asks questions, kindly drop them in chat box now. But now the chat box has been on. There are no questions yet. So in case you want to speak to the mic, you can kindly unmute yourself and ask your questions. Pending that, I actually have one question, sir. And it's actually about genericide. That was a term about trademark that I came across recently. I'm talking about genericide, whereby a particular trademark has become so generic that it has lost the distinctiveness it's supposed to have. What is the best shot for the owner of that trademark in trying to protect it from losing the trademark on that particular mark entirely?
Okay, so genericide, like you said, is actually a good thing that has led to a bad thing. So when a trademark becomes so popular, under the law, if a trademark becomes so popular that you can say that this trademark is a well-known mark, that mark usually will have a lot more protection than the ordinary trademark. It will have a lot of incentives. You can register it as a defensive trademark and the rest of them. But now there are instances where the mark can now become so popular that it now loses its distinctiveness and becomes a generic word for so many things. So many trademarks, so many words that we use today, biro, cellophane bag, escalator, all of them used to be trademarks for some companies, but today they are all common words that everybody's free to use. There are some other trademarks that are even on their way to genericide if care is not taken. Now, the usual advice would be to companies, right? Things that you can do to make sure that your mark does not fall into that state of being generic is, first, if your product is the first product of that kind and you have a trademark for that product, as well, try to get a generic name for that product and use both of them in your adverts. For example, when Indomie came into Nigeria, right? I know it was the first product of that kind. If the company had been using Indomie, people will end up using Indomie to identify all kinds of noodles of that, any food that appears to be like that, they will call it Indomie because that's the only name we know. But if you say Indomie is the trademark, the brand, and then noodles is the general name, that is where people will know, okay, that this is Indomie instant noodles. Indomie is the brand name for this particular one, while noodles is the general name for the others. So there will be that understanding. Again, you try as much as possible to use your mark in the noun form. They say noun is a name of a person, animal, place, or thing, while verb is action or doing what. People end up using some trademarks in a verb form, which makes it to go genericide. For example, we say that one every day. Instead of telling me to go and search for something online on the internet, you can say, go and Google it. You are using a company's trademark in a verb format as an action word, go and Google it. That's a way it ends up being generic. Instead of the right way would have seen, go and search for it on Google. That will give the impression that Google is a brand or a thing, the way a noun is being described. Another way is always use the trademark in capital form, just like a noun. If you're writing something and you have to write using the same Google as example, then you have to be using capital G to indicate that this is a noun, this is a thing, and not an action, a verb kind of thing. And, there are so many things they can do, but let's just take these few instances because of time.
All right, thank you very much. I really appreciate your response to the question. So right now we have some questions in the chat box, but looking at the participants, we already have the next speaker who is waiting in line because she's supposed to start her session by 4 o'clock. So I will need the indulgence of Mr. Aniukwu to kindly hold on. Probably after the next session, we just give you time to address the following question. So yes, moving on to the next speaker now. Thank you so much, sir. Please, Miss Victoria, Miss or Mrs. I'm so sorry, Victoria Oloni. Now, this is her profile. Now, she is an innovative lawyer with experience in providing legal and general advisory on data protection, cybersecurity, the digital economy, and general intersections of technology and law. She contributes to the data protection space and the tech ecosystem in general by providing legal general advisory services and thought leadership through her publications and speaking engagements on topical issues within the ecosystem. She's a key member of the METIS, that's Media, Entertainment, Telecommunications, Information, Communication Technology, and Sports team of Corporate and Commercial Practice Group of Templars, a leading law firm in Africa. She's certified Information Privacy Professional, that is CIPPE, with the International Association of Privacy Professional, IAPP, where she also served as a young privacy professional for the 2022 leadership cohorts of the IAPP Nigerian Knowledge Net chapter. With a very warm welcome, we welcome you to the session today, and you can take the floor now. It's just man. Thank you.
Good afternoon, everyone. Just confirming that everyone can hear me.
Yes, ma'am. Good afternoon. We can hear you.
Thank you. Just give me a minute to share my screen. I'm not able to share my screen.
Okay, let me make you a co-host, Victoria, so that you can share your screen.
Thank you.
Okay, so you can. Okay, awesome.
Yes, I can. Just confirming everyone can see my screen. Hello?
Yes, I can.
All right, thank you very much. So, as the moderator has said, my name is Victoria Oloni. I'm an associate with TEM class, and I'll be walking us through this class on data protection or data privacy compliance for tech businesses. I have a bias for data protection over data privacy, so I made that tweak. Anyways, I'll try to make it maybe as simple and straight to the point as possible. I'm not sure whether I'm facing an introductory, an intermediary, or an advanced class, so I'll just make it basic. So why is data protection compliance important for tech businesses? Because I believe it's important to understand that before we go into how to be compliant. So we're not talking about this because data protection is now just popular or because it's in. It's because
this meeting is being recorded.
We're in the digital age, so what people call the fourth industrial revolution, and a lot of people describe data as oil. There have been arguments for and against that position, but that's not the focus of this class. So the tech space, tech companies thrive on data. When you look at the big tech companies, what we call the FANG, Facebook, Amazon, Apple, Google, Netflix, to a large extent, their business models thrive on data. When we bring it home to startups in Nigeria, tech companies within Nigeria, we see how much these organizations thrive on personal data. You want to do anything, you have to register, you drop your name, your phone number, your email addresses, your birth date, your gender, and a whole lot of personal information. You want to open a bank account, you fill the KYC form, you want to do anything, except you live under a rock, you can almost not go a day without filling a form where you surrender some sort of personal data to someone. And I don't think it's possible to run a business in Nigeria at the moment and you will not process personal data. Maybe people who are listening can suggest businesses like that. Okay, maybe when you buy pepper, maybe buy pepper from a roadside vendor, you don't have to give them your name or anything, you just give them your money and you collect your pepper, maybe. But for a tech business, it's now a literal impossibility to run a tech business and you are not processing data. As a data controller, as a data processor, because if you are processing the data of your employees, you are a data controller, regardless of what kind of business you do. So that's just giving a kind of background. And I have this quote from the head of global privacy for LinkedIn that I thought encapsulates everything I'm about to say in this masterclass. Data privacy has become something that is not just for lawyers anymore. So it's no longer, oh, I'm not a lawyer, it's not my business. At LinkedIn, we call it a culture of privacy because it's not just the lawyer's responsibility. Our job is to help interpret the laws, but it is really the responsibility of everybody at the company. As a data-driven company, LinkedIn, that's an important thing for every employee to understand and get a sense of. So a lot of the work that we do here at LinkedIn is to make sure everyone feels the culture of privacy and they are aware of the responsibilities we have. So one important thing I got from here is that data protection in an organization is not the work of legal and compliance alone or the work of your DPO alone. It goes down to everybody. For example, a data breach can happen anywhere. It could be your gate man giving away a printout list of people who attended an event. It could be your receptionist opening a phishing email with a malicious link, and that's how the breach occurs. So at that point in time, legal and compliance cannot sit in everybody's office monitoring what they do and don't do on their systems or how they manage and process information. Everybody is an avenue for a breach of data protection compliance. So it's important that not just, oh, let me send my legal and compliance for the training, unless you want them to come back and then train people in-house. Everybody must pay attention, from CEO down to the receptionist, down to secretaries, executive assistants, because it's everybody's business, especially because of the nature of the tech space. So introduction, I think I've given an introduction. This masterclass is designed to help tech professionals, blah, blah, blah. I've given an introduction. The objectives of this session: understanding data protection laws and regulations, gaining knowledge of data protection best practices, being able to identify and mitigate privacy risks, preparing for privacy audits and assessment, awareness of emerging trends and challenges. Before I forget, because if I say I'll say this later, I might forget. So under the NDPR, data controllers who process the data of over 1,000 people in 6 months or 2,000 people in 12 months are required to submit their data protection audit reports. I'll probably explain audit report later, but you're required to submit by March, I think March 15. So it's important to start conducting your audits right now if you want to meet the deadline. I just thought to mention that before I forget. So I'm moving to the relevant laws. I'm just going to browse through all these parts as quickly as possible because it's not the main focus of the class, but it creates some sort of foundation. When I'm saying NDPR, we understand what I mean. The NDPR, which is the Nigeria Data Protection Regulation 2019, is the primary data protection law in Nigeria at the moment. Yes, the subsidiary legislation made by a government body, but that's what we have at the moment. It's like our version of the GDPR, which came into force in 2018, a largely watered down version, but that's the primary data protection law in Nigeria at the moment. Then pursuant to the NDPR, NITDA also issued the implementation framework to provide some context with respect to implementing and how organizations should work with the NDPR. We have the public institution guidelines that relates to public institutions, and we have other laws.
Sorry, would you like to share your screen, or you're comfortable with just speaking without sharing the screen?
I was sure. I think my screen stopped sharing at the point.
Oh.
I will share my screen. Okay, this is what's going to happen.
Okay.
My bad. I tried on my screen. Thank you for calling my attention to it. Now I'm trying to find that.
No problem. Let me check. Can you share it now? I think you're a co-host, so you should be able to share at the moment.
I can share my screen. I'm just trying to find this.
Oh, okay.
I don't want to share the PowerPoint. I want to share the share. Okay.
Mm-hmm.
I think is what I'll have to work with.
Awesome.
I'll share the PDF, but I'll just work with the PowerPoint. Can you see my screen? I was pretty sure I was sharing, so I've just been talking to myself for like 5 minutes. Thank you for calling my attention to it.
You're welcome.
Yes, so back to the relevant laws. So we have the NITDA Act. I included this because we cannot talk about data protection in Nigeria without talking about NITDA, although they are no longer the regulator, because last year, in February, so it has been a year since the NDPB was established. So the Nigeria Data Protection Bureau took over the data protection responsibilities of NITDA in February last year. So, but NITDA issued the NDPR and the implementation framework. So they are an important part of the data protection history of Nigeria. Then the Constitution of Nigeria, the ground norm, lawyers like to call it the ground norm, from which every other law emanates, and any law inconsistent with the Constitution of the Federal Republic of Nigeria shall be declared null and void to the extent of its inconsistency, as lawyers like to say. So in some sectors, at least, there is a belief that the right to data protection emanates from the right to privacy under Section 37 of the Constitution. We have the Cyber Crimes Act, which has some data protection flavor, especially when it comes to breach reporting. We have the Freedom of Information Act, which in I think Section 15 of the Act also has some data protection sections, especially with respect to public institutions. We have the Credit Reporting Act, the NIMC Act, some sector-specific laws, particularly from the CBN, that have consumer protection and data protection flavors. So these are some of the relevant laws we look to when we want to understand the data protection regime in Nigeria. We go to the regulators, as I said, the Nigeria Data Protection Bureau and NITDA, then the FCCPC. The FCC, although in the FCCPA, interestingly, there are no data protection provisions, unlike in the Consumer Protection Act, which was its predecessor. For some reason, it was taken out. But the FCCPC has them also gotten involved, especially with respect to the activities of digital lenders. So NDPB and the FCCPC partnered. I think they signed the memorandum of understanding of some sort because of the illicit activities of digital lending apps. So I think everybody will be familiar with what these guys do. You must have gotten some sort of message saying someone has run away with money, you are their guarantor, or if you see them, you should contact.
This meeting is being recorded.
That's what happens.
Victoria, no worries, just go on. If it's a problem with network or something, just go on.
Okay. Anyways, anytime I notice it, I will reshare.
Okay.
I'm keeping my eye on. There's a pop-up here that makes me know that I'm sharing my screen, and when it goes off, I will see it. So we have the CBN for the financial services sector. So the financial services sector is in the black zone of data processing because of how much the sector thrives on data. KYC, AML regulation is such a vital part of financial services. There's so much data processed in that space, and it brings CBN into the picture. CBN doesn't have an official framework for a couple of years now. We've heard that they've been working on one, but I will not be surprised if they come up with a regulation specific for that sector, because CBN is CBN. Every 2 to 3 business days, they issue something. We also have the NCC for the telecoms guys. They are also very big time data controllers. So these are some of the regulators in that space. So now we are moving towards the more important part of this class or training, importance of data protection compliance for tech companies. So I try to give a background of this. Why is data protection compliance important? Why should you care about it? Because it costs time to be compliant, it costs money, it costs manpower, it costs a lot of effort. And you cannot pour these things down the drain for something that is not even necessary or important. So, one, it's a legal obligation. When you look at the laws of the regulators that regulate you, it's something these laws are becoming very big on. Because at the very base of it, data protection even though this is argued here and there, whether it's an economic right or a human right, it is a human right. At the very base and foundation of data protection are the data subjects, human beings, whose personal data have far-reaching effect, like what you do with their data has far-reaching effect. Things like identity theft are often born out of data being misused or carelessly handled, data leaks somewhere, somehow. So it's at the very base of data protection, we have actual humans who are affected by the actions of big corp. Everybody heard about the Cambridge Analytical scandal, or how in the US for the Donald Trump election, the election was manipulated because by processing data a certain way, they were able to understand pattern of human behavior and know the kind of advert to show who to influence their voting choices. So data is so powerful that it can be manipulated for good and bad. I'm not saying data processing is inherently bad. Arrest all big tech companies. No, these people provide wonderful services for us by processing our data. For example, they can give you ads curated to your particular needs. For example, you know, everybody now, we believe that our phones are listening to us. So when you talk about something, for example, and then you open Instagram and then you see that the adverts on Instagram are probably about a conversation you had either via text or via speech. So sometimes when I'm looking for something, I pick up my phone and I say to it what I'm looking for. And then I close my Instagram and refresh it. And then in a couple of times it has worked. And the adverts have been useful to me. So it is not always a bad thing. It's just that it is too powerful to be left unchecked. The power of data is something that is too much, too intense to be left unchecked. And that's why a lot of governments are beginning to regulate that space very strictly, like they do for the financial services. Because financial services is probably one of the most regulated spaces anywhere in the world, money. But data is probably more important than money because of what it can be used for. So you have legal obligation. You have a legal obligation to be compliant. There are laws, there are penalties, there are
This meeting is being recorded.
okay. Consumer trust, I'll go back to the Cambridge Analytical issue. Now, anytime someone says, oh, Facebook, people are skittish, like, or Meta. Because of that scandal, Cambridge Analytical is bankrupt. And there are examples of companies who have gone bankrupt because of one data breach, because of one mistake, probably intentional or unintentional, that has happened, and the whole business wiped out. So consumers trust, the moment consumers become skittish about using your tech business or your platform because they know their personal information is exposed, it breaks consumer trust, and that's the beginning of a dying business. Competitive advantage, and we all know browsers like Brave, DuckDuckGo, what they sell is privacy. Oh, we are a privacy whatever browser. They don't store your browsing history, things like that. That's their competitive advantage. That's what they sell, different from Chrome, Safari, Internet Explorer, things like that. That's their competitive advantage. That's another. So they say, oh, we are compliant with the law. So I remember last year, the NDPB issued, maybe it was NITSDA at that point, but I don't think NDPB had really started off completely, issued like badges for submitting your audit reports. And people put it on their website that they are NDPR compliant because they filed audit reports. That's not true. You are not compliant because you filed an audit report, but because they were compliant on that part, they got their badge and they were able to flaunt it. And it gave them like maybe a competitive advantage. I am compliant, use my business. Reducing legal risk. So personal data, processing data exposes you to a lot of risk, a whole lot of risk. And when you are compliant with the law with respect to this and best practices, it goes a long way to help you at least reduce or mitigate some of these risk factors that will affect you if you are just like, nobody cares, we're in Nigeria, who enforce the law? You just, there's a way it happens that you will just be a scapegoat, and it will be rather unfortunate. Avoiding legal penalties and reputational issues. So I'll be going to the next slide. So we can see that under the GDPR, and even in another slide, you see in China too, that the European data protection authorities and regulators, they are not playing at all. So in Nigeria here, I think only about 3 organizations have been fined. We'll get there. These guys are not playing at all. They fine businesses. For example, Marriott was originally fined 99 million pounds, although it was reduced to about 40 million pounds in the end. But that's a lot. In 2022, that was just last year, Instagram was fined $403 million. Amazon, 636 million pounds fine for non-compliance with the GDPR. We can see H&M, we can see Google. Google has been fined multiple times. Same for Meta. Meta has been fined. Facebook has been fined. WhatsApp has been fined. Instagram has been fined. I'm sure the regulators love those organizations because they are a steady income generating platform for breaching the law. So these guys are fined very heavily. And then they also have reputational issues. For example, when you look at a group of companies and you see that in the same 2020, WhatsApp was fined, Facebook was fined, Instagram was fined, then Meta as an organization was fined. It's a red flag. There's a data processing reputation that Meta and its company has that is bad. And everybody is weary, very weary about it. Then we come to the largest fine anywhere in the world. It came from China, where DD Global was fined $1.1 billion for not complying with Chinese data protection and security law. That's how much fine you can attract. In Nigeria now, we've had like 3 fines. 2 of them were tech companies. One was LIRS. So LIRS got about 1 million. Loan got 10 million. So Loan, I think, the digital lending app, they were the one that brought the attention of the FCCPC and NITDA to the activities of digital lending apps. I think they were reported maybe sometime in 2018, but nothing happened till 2021. There was a lot of investigation and things of that nature, and they were finally fined. Then we have ESL. ESL, they came down very heavy on them. Their fine was not as large, but there were a lot of things they were asked to do apart from the fine, which we want to avoid. Under the NDPR, you can be fined up to 20 million naira, or up to 4% of your turnover for the year, whichever is higher. So it's a risk. It's not very common as we have in Europe that people are fined, but it's a risk. The regulator can wake up tomorrow and become extremely active, and you are the first person in line for their hammer. So it's something we need to pay attention to. Key issues in data protection compliance, I think I will move past this. Here I talk about principles of data processing, lawful basis, data subject rights. Let me just do that in passing. Principles for data processing. So as a data controller or as a processor, let me just explain this in like one line. Data controller, you are the person who determines how, where, when, for what reason data is processed. The data processor, you are the one processing the data. So for example, I am a biscuit manufacturing business. I have employees. I have customers. I don't want to do payroll activities by myself. So I outsource payroll to Mr. John's payroll company. So Mr. John does payroll for me. I tell him what to do with my payroll. This is my payroll. Pay my employees or trigger payment of salaries for my employees on the 10th. do so and so with their data, process their data this way, that way. For that payroll personal data, I am the controller. Mr. John is a processor. He's not the controller. It doesn't determine what happens, but it's processing data on my behalf. So basically, the data processor processes data on behalf of the controller, but the controller is in charge of what happens to that data. But these things concern both data processors and data controllers. And I don't think it's possible for you to be a data processor only and not be a controller. For example, Mr. John, although he's a processor for my payroll data, for his own payroll data, he's a data controller. So we need to look at all these things contextually. The fact that your business model is data processor, but you interact with people and you process their data for your own sake, you are a data controller. So you are supposed to abide with the principles of lawfulness, fairness, and transparency. This means you must have a lawful basis for processing data. In Nigeria, under the NDPR, there are 5, which is consent, contract, vital interest, public interest, and legal obligation. So there is a 6th one, legitimate interest, which for some reason didn't make it into our NDPR. But in the Nigeria Data Protection Bill, I forgot to mention that under the relevant laws, there is a 2022 bill before the legislature at the moment. I don't want to be too optimistic because there's almost no year we've not had a data protection bill in the past 5 years. But the legislature has expressed a lot of optimism, and they seem very willing or interested to pass this particular bill. So fingers crossed, let's see how things go. So you are supposed to process data based on one of these lawful bases. So either your consent, contract. I know in Nigeria and a lot of countries we like to double down on consent. Consent is just one of them. In fact, my general advice would be only use consent when you can't find any other lawful basis, because it is probably the worst lawful basis you can rely on as a data controller. So when you think about it, because once you use consent, the data subject has a right to withdraw consent. When the data subject withdraws consent, can you stop processing that data? Ask yourself that question. Can you stop? So that's why I said consent will be the worst one you can rely on as a data controller. It gives data subjects almost all rights. All right, they can object, they can withdraw consent, ask you to delete, ask you to, they can exercise their right for data portability and all that. It's fantastic for data subjects. Left to all data subjects, consent should even be the only lawful basis. But it's not always realistic to use consent because of the standard for consent. It must be freely given, it must be specific, unambiguous. These are things that might be difficult to ascertain, and then it can be withdrawn at any time. It becomes an issue in the middle of your process, and the data subject comes and says, I don't want you to process my data again. In fact, delete it. Is that something your business can rely on and continue to run? For example, if you are a dispatch business, you want to deliver products to a customer, you cannot rely on contractual obligation. You cannot perform your side of the contract without processing the person's address. It's impossible. So you don't need consent in that instance to process the person's name and address, because you are in a contractual relationship. Help me deliver this shoe to this person. Help me deliver this shoe to me. I order this shoe, help me pick it up. God is good with logistics. Help me pick it up and bring it to me. You don't need my consent. You don't need my consent because you need to process my personal data to carry out that service. You are shooting yourself in the foot if you choose to rely on consent in that instance, because now you have like a long list of things to look at to ensure that consent is valid when you don't even need it. I shouldn't spend too much time on this. Let's move on. I think we'll still touch on it later. Then we also have purpose limitation. You must only process data for the purpose you said you want to process data for. So you don't collect people's data for one thing and use it for something else without going back to them to tell them you want to change your purpose. Data should be used for the purpose it is collected. Don't say because someone attended an event, they wrote their name down, maybe because of the certificate you want to issue to them. Next week, you are now sending them, next week, you now transfer their data to your sister's company that is a baking company that is doing promo. So you probably organize maybe a master class of some sort. You got people's personal data and they gave it to you for that purpose. Then you collected it and said, well, I now have the data. You now transferred it to your wife or your husband's business so they can send them promotional flyers for their Valentine baking promo. Now that's where there's an issue. You've switched purpose for processing and the data subject does not know. Now I'm in my house wondering how Jehovah is great baking shop got my data to be sending me direct marketing. This is one thing that we should avoid as tech companies. Data should be processed for the purpose for which it was collected. Data minimization. Collect only data you need to perform the activity you want to perform. So things like maiden name, there are weird things that I see on forms that you automatically know that this thing is completely useless. And how you know is that the moment it's not a compulsory field in a form, it's not useful data for that purpose. So why are you exposing your business to this, to collecting data that is not necessary for the purpose you want to use it for? Eliminate data fields that are not in any way attached to your purpose for processing. It just saves you a lot of when you are doing your data inventory. Make sure you only collect data you need for the purpose. This probably let's move past accountability. You must be accountable as a data controller. So that's the approach the NDPR and the GDPR have adopted. Show accountability that you are compliant with the law. Things like audit, DPIA, that data protection impact assessment, appointing a DPO, having a privacy notice. These are things that are accountability measures, and this is the standard the NDPR has adopted. Storage limitation. Personal data should be kept only for as long as necessary for the purpose of processing. It's not advisable that you store personal data forever. You collected it for a temporary purpose. The purpose has been fulfilled. Delete, archive, anonymize. Stop processing data in infinitum forever. Once the you delete, you archive, or you anonymize data. Pseudonymization does not take you out of data protection law coverage. Pseudonymized data is still protected by data protection laws. That's why I said anonymize instead. That lawful basis, you have consent, contract, vital interest, public interest, legal obligation, legitimate interest, data subject rights. So data subjects have a right of access, right of rectification. So data subjects have a right to say, I want to see the personal data you have on me. That's why you see on your Twitter, your Facebook, even your Google, you can see the data Google has on you, personal data. I can't say that is everything they are showing you. I don't know. I'm not in their internal process, but at least there is some sort of compliance with that. And like then rectification, you should be able to rectify your personal data. I remember I had to deal with an app once. There was a mistake somewhere with the app, and I couldn't rectify it. I couldn't change it. There was no option to change it. So once you, the same way there are some apps that you cannot delete your profile. That's another conversation for another day. You can't delete your, once you open the profile like that, you die there. You can't delete it. It's ridiculous because data subjects in certain instances, they have a right to erasure, or what we like to call the right to be forgotten, exercisable in certain instances, not an absolute right. But for you to say it is impossible for you to delete your profile or maybe a food delivery app, why? That's where some of these issues start from. And that's when people begin to pay attention to, okay, this website that cannot delete my data, it doesn't even have a privacy notice. And you begin to, for little basic things like that, is you don't want to be fined heavily because of, you don't want people to be able to, why don't you want people to be able to delete their profile? It's something that I try to rationalize things a lot and see things from another person's perspective, but I've not been able to rationalize that position of why you don't even have an option to rectify your data. Even if you say bring your NIN, ridiculous sometimes, for you to be able to rectify. I understand, but for you not to have the option at all, you are basically breaching data subject rights. The right to data portability, right to restrict processing, right to withdraw consent, right related to automated decision making, cross-border transfer. So this is a very interesting subject matter on that data protection now, because the world is a global village. A lot of tech companies in Nigeria don't store their data onshore. We don't store our data in places like Main One or other places. We don't store data onshore, or even cloud services onshore. We store, people are using maybe Amazon cloud services and things like that. And the moment you are moving data outside Nigeria, now this is a gray area, because it might be a gray area. The gray area is whether when you access data from outside Nigeria, it qualifies as cross-border transfer, or the nature of cloud services itself. Because you might not be able to particularly determine where the cloud service is. It's something the data protection laws are still trying to determine what their position will be. But there are some that are clear-cut cases of international transfer of data. Once you are moving data across borders, maybe your headquarter or your holdco is now in Delaware or something, and then you are moving data, and they are not just a shell, they are an operational holdco, and you are moving data across borders. Now cross-border data transfer becomes important. I'm running out of time. Transfer to a foreign country can take place. So in Nigeria, we have something called the whitelist. The whitelist is at the back of your data protection implementation framework. It has a list of all the countries that Nigeria believes has adequate data protection framework. You can transfer data to those countries as you like without having to take any extra step. So the moment a country is on the white list, you can move data across board. You can move data there, you can transfer, you can store your data there, you can process your data. And you want to move your data there, you have to take an extra step. So maybe you have to get the consent of the data subject, or it has to be in fulfillment of or maybe you have to rely on vital interest or a legal obligation or a contract. You have to rely on something extra if you are moving data across borders to a country that that's not on the whitelist. In Europe, they call it a country that does not have an adequacy decision. Nigeria doesn't have, no African country actually has an adequacy decision from the EU. So the EU sees Nigeria and Africa as trenches that their citizens' data should not go to. Developing and implementing a data privacy compliance framework. So some of the key risks breaches is no longer a matter of if, it's now a matter of when. Because every time there is new technology is another issue here. People are coming up with new ways to scam people. Scam is a popular way, new ways to access data illegally. So data breaches now is something you can only prepare for, probably not prevent 100%. So you do your part to prevent, yes, but you must also be prepared because it's something you cannot 100% write off. Our business can never be compromised. That is the first, you are the next target, basically. So it's a key privacy risk, insider threats, and employees. Employees are the weakest link in any data security program. Human beings are fallible. So, and human beings like a wolf. Maybe someone will just share, send an email saying 50% off, maybe during Black Friday period, and someone will click on it, and the whole IT system of an organization is compromised. That's why it's important to train employees, and I think the laws recognize how important it is to train employees because it's written in the NDPR, it's written in the implementation framework that organizations are supposed to train their employees on data protection every year. So it's a repeated training, not that the NDPR came into force in 2019. We brought on consultants to train us, and since then there has been no refresher. Everybody has forgotten who is thinking about the NDPR when that is not their primary responsibility. So it's something that must be continuous. To mitigate risk posed by human error, it's important for tech companies to implement comprehensive security programs that include training employees, telling your employees to use strong passwords, not 1, 2, 3, 4, 5, or their birthdays, or the same password for everything. Employees are probably the easiest way, whether they are complicit in whatever data breach occurs, or they are just what they call them, innocent actors. It's important to train employees, tech companies. Privacy and data protection is not the business, I'll repeat it again, of only legal compliance or your data protection officer. It's everybody's business, because when something happens, it affects everybody in their entirety. So it's important to train employees. Now we look at developing a compliance framework. So in developing a compliance framework now, you have to identify the laws and the regulation, because you can't create a framework in vacuum without looking at the laws. You can't download a template from the internet, adopt it hook, line, and sinker, and be happy and say, wow, we have a data security framework. The person that uploaded it on the internet, thank you very much, but they looked at certain idiosyncrasies of their business and applied it. So you cannot adopt as a fintech, you can't adopt the data security framework of a different kind of business. Just download it hook, line, and sinker. Your data processing operations are different and are very sensitive. So you look at the laws, you look at your operations, you develop a data inventory. Now, this is probably maybe the hardest part, identifying the kind of data you process. What do you have? What data do you have in your data bank, in quote and unquote? Which ones do you need to delete? Which ones do you need to anonymize? Which one do you need to archive? Which one do you need to classify? So I remember at the time I had to draft a data classification policy. So for you to know that we process sensitive data in this organization, you have to look at the kind of data you have. What sensitive personal data? Things that show a person's sexual orientation, or that show a person's religious affiliation, political affiliation, things like that. If you process sensitive personal data, the compliance mechanisms are slightly different. Your standards are higher. So if you don't even know that you are processing sensitive data at all, because you don't have data inventory, you don't know the kind of data you have and don't have, there is a very high probability you will be in breach, because you didn't even know that, oh, I'm processing sensitive data, so it is compulsory for me to have a DPO. But there are certain things you do that make certain things that are optional for everybody to be compulsory for you based on the kind of data you process. So you conducting a DPIA, the DPIA is Data Protection Impact Assessment. This allows you to evaluate the kind of risk that your data processing poses to data subjects. So under the NDPR, everybody is supposed to do it. Yeah, it's a standard. You're supposed to do a DPIA, but there are certain things you do that make it compulsory for you to do a DPIA. When you process data that leads to systematic monitoring of human behavior, maybe you have surveillance cameras running 24/7 monitoring maybe a major road, you might, it's in that instance, it's now compulsory to do a data protection impact assessment. Employ a DPO. This is optional, kind of. In the NDPR, all data controllers are required to have DPOs or people who carry on that role, whether or not they have that name. So the person doesn't have to be named a DPO, but you must have someone in an organization who doesn't answer to legal and compliance, but answers to top management. The person is independent. The person is like a watchdog within an organization. Your data protection, that's why it's very funny when people combine legal and compliance with DPO. That's murky waters, and it's like you are looking for trouble, because a data protection officer is supposed to be completely independent, answering only to management, not to fellow employees, because they are the watchdog within the organization. Now, under the implementation framework, there are certain things you do that make it compulsory for you to have a DPO, e.g., processing sensitive personal data. So when you look at that's why I say it's important to identify the relevant laws. So you know that there are certain organizations that having a DPO is not an option. It's a must. It's a requirement of the law for you to have a DPO on your payroll. Someone who, and the roles of DPO, thankfully, are defined in the implementation framework too. So who can be a DPO, what the qualification is, what their roles and responsibilities are is defined in the implementation framework. So creating a data retention and disposal policy. So it's better you have these things documented so you can pass it on for posterity. In this organization, these are rules on retention and disposal. At the beginning, you get someone to design these things and you update regularly as the laws change, as your business model evolves, as the kind of business you do evolves. This is something you have to have. Establishing security procedures and protocols, just like having an incident response plan. You should have a security procedure. You should have a set of rules that control how your security works. So you can outsource it to experts. Otherwise, there's a place where you engage with external experts. There are some things the organization doesn't have the capacity to do in-house that you have to outsource. So that's why these big techs, they'll have data protection officer for each region, have a whole department dedicated to it, but they still have law firms on speed dial that give them data protection advice. Because some of these things, you need people who are in the field, who external experts, to have a second look at some of these issues for you not to be non-compliant. Then train employees, I already spoke about this. Developing an incident response plan. Like I said earlier, data breaches now is a when issue. There's almost nobody that has not suffered a data breach in recent times. A lot of people have been able to put it down, hush hush. There's the time Manchester United even suffered a data breach, so nobody is immune. It's just that, so you have to have a data breach response plan. What do we do when there's a data breach? How do we inform the regulator? How do we inform data subjects if we believe that this thing will impact them, or the law says we should inform them? How do we recover? How do we turn off how do we treat data breaches? So it's important to have a plan, because sooner or later it's going to happen. And how prepared you are for it is what will determine how bad the situation is. train employees, engage with external experts, conduct regular breach drills. So there are sometimes we read all these funny stories on social media. I'm rounding up now. All these funny stories on social media that, oh, I got a coupon from HR saying I got something, and I clicked it, and then my system went off, and now I have to do a 1 month training on phishing emails. It's necessary because this time around it was a drill. The next time you click it, it might be a malware that will shut down the system of the organization, and then everybody hands are tied. So we're not, the way we have fire drills in organization, it's important to have breach drills, and then you anticipate breach scenarios. So you should think about it. There's something, we are very averse to things like the same reason we don't like insurance in this part of the world. It's the same reason people will probably not want to do this, because God forbid is the best insurance policy in the world. We don't want to believe something bad will happen, but something bad can happen. Is it not better to be prepared for this something bad than to close your eyes and pretend it can never happen? So we need to prepare for data breaches, like you prepare for your end of the year bonus, or prepare to pay your employee salary every end of the month. It is something we need to consistently and constantly be prepared for. Then review and update policies regularly. So it's not enough to say, we have an elaborate number of policies for data retention, disposal, data classification. We have a privacy policy, we have notices. We prepared in 2016 and they've not been reviewed since.
Hi, Victoria. You have about
Yes?
minutes more.
Yes, I'm rounding up now. Thank you very much. The laws have changed. Your business model has probably evolved. Your customer base has probably changed. You cannot be using a policy you designed in 2015 and be so proud of it because it's elaborate. It's most likely outdated. So you have to review and update your policies regularly. It should be under constant review. It's not a one time for all, we thank God this is done situation. It's something we must continue to look at. So as tech businesses around up, it's important we take compliance seriously. As we look at AML, CFT compliance, CBND's compliance, if you are a fintech, this compliance, data protection should not take the back seat, because it's just equally as important. That's why a lot of these regulators recognize it even in their own laws, that you're supposed to be data protection compliant. So every day, if possible, think data protection compliance, be proactive. Don't wait for something bad to happen before top management pumps money into data protection compliance. Let's all be proactive. It's the business of everybody, and let's make sure all our employees are also very data protection compliance conscious. Thank you very much. I think, we've come to the end. Let me go to my question slide. Any questions?
Awesome. Thank you so much, Victoria. That was quite informative and very enlightening. Can you hear me, please?
Yes, I can.
Awesome. So if there's any question at the moment, please let us know. Okay, in the absence of any question, because we are already, time is already fast spent. So let's just call in our third speaker at the moment, our third facilitator. Temi, are you on the call? Temi is supposed to be the anchor. So please let me just quickly check if he's on the call before we proceed.
I am.
Awesome. Okay, please proceed. Thank you.
All right, thank you very much.
So I think this is more of a network issue. Thank you so much, Victoria. Victoria, please, could you, okay, it looks like your slide is still, could you stop sharing your slide, Victoria? Okay, thank you. So it looks like the anchor is having some issues. Probably is a network issue. Okay, okay. Okay, so we'll be moving right into the next section. We have our facilitator in the house, and I'm super excited she's here with us. She is Adefunke Adeyeye. So I'll proceed to read our profile so that we can continue. How many of us enjoyed the last section? I particularly enjoyed it. Thank you so much, Victoria. You're really, really fantastic with presentations, and I think you're a good teacher. Thank you so much. I learned a whole lot. Okay, so moving on. Adefunke Adeyeye obtained a Bachelor's of Law degree from the University of Lagos in 2024, and she was called to the Nigerian bar in 2025. She has an LLM with specialization in international law, and she is a member of the Chartered Institute of Arbitrators UK. She is currently a senior counsel at Halion, a world-class consumer health company, and she is responsible for its anti-counterfeiting agenda across 150 markets in Europe also, Middle East, Africa, America, and all the parts of Asia. She has received awards in Nigeria and internationally, which includes being recognized as top 40 on the 40 lawyers in Nigeria twice, one of the 7 outstanding legal professionals in Nigeria, top global IP leader, and was featured by the UK Lawyer as a top lawyer in its African series on doing business in Africa. Adefunke is passionate about female empowerment, which bettered her mentorship program called Wig, Heels, and Boardroom. I'm proud to say that I'm a part of this mentorship program, focused at empowering female professionals of African descent. Ladies and gentlemen, please welcome Adefunke Adeyeye. The floor is yours, ma. Thank you.
Thank you, Ololade, and hello, everyone. I'm particularly happy to be here today, not just because what I'm about to talk about is something that I'm very passionate about, but I was called to the bar in 2004. Not 2025. We're not in 2025. I like you dreaming about the future, but it was 2005.
Okay, 2005.
Yes, but it's fine. I mean, it's good to dream in the future, but it's fine. But I'm particularly happy because this is something that Ololade has been able to bring to life, and I'm very proud of you. Well done. I mean, I was listening to the last speaker and I did learn a lot. I think I joined like 15 minutes to the end of her session. So well done to you as well, Victoria. I think for this session, I'm going to make it a little bit interactive. Is there a process where people can actually speak if I ask a question? Is that possible?
It's fine. It's fine.
Okay, so you've titled this segment as Anti-Counterfeiting Measures for Brands. And I've been working on counterfeit for the last 5.5 years of my career, and it's something interesting. I think the good thing about working in this field is everywhere you go, you don't want to do any fake. Wherever you go, you always watch out for, is this the fake one? Is this the genuine one? You know, and all of that. And we're all Nigerians. I'm sure that the fake things are all over our faces. You know, sometimes I look at the luxurious brands, and when I go to sessions with them, I tell them you only need to come home with me and you see all your products, you know, flying around and everything. But to start with, I know that we all hear counterfeits all the time. I don't have a slide because I want to interact with you. You know, it's a masterclass. I'm supposed to teach and I'm supposed to learn. That's how it works better. So I don't know who's going to volunteer. 3 people, when you hear counterfeits, what comes to your mind? Any 3 volunteers? Okay, Oluwateniola, yes.
My counterfeit. I think fake. Something is fake when it's counterfeit.
Fantastic. When it's counterfeit, it's fake. That's cool. That's just a simple way of describing counterfeits. Thank you, Teniola. Any other person? Wow. No other person wants to tell me when you hear about counterfeits. I mean, we hear it all the time, I'm sure. Okay, I take that as a no. So basically, like Oluwateniola has said, when you hear counterfeits, it means that the thing is fake. I know that early on in my career, there was not a lot of fuss about counterfeiting, brand protection and all. That's also because for a lot of multinationals, these things are managed from the global office, not the local offices. But to start with as well, so when you talk about counterfeit, what should come to your mind is, like Teniola said, it is fake. But it's not just fake. The person making it is imitating someone else's intellectual property, someone else's patented product, someone else's trademark, just to deceive other people. So that's why counterfeiting is a very specialized field. In most organizations, it sits under intellectual property. In some organizations, it sits under corporate security. Ultimately, it sits under legal. And I want to believe that most of us on today's call are lawyers. So when you hear counterfeit, that is someone else that is infringing on someone else's trademark, someone that is stealing someone else's products to deceive people, to defraud people, because they always make money out of it. It's a criminalized world, what the counterfeiters do, because it's not just the one-man show. You know, they spend little to put out the fake products and then deceive people. So before I talk about my brand, if you go to like the luxury goods, which I see everywhere, and I'm sure we all say the Louis Vuitton, the Chanel, the Prada, it's everywhere. And it's not just in Nigeria. You know, I see it everywhere in Nigeria, probably more, maybe even almost more than China. China produces it, but they don't really use it. But there's a local market in Turkey. When you walk into that market, everything is counterfeited. I went there and we were talking to one of the sellers, and it was interesting what he said. I was with a British colleague of mine, and he said I should drop the mine behind me and that he was going to talk to me because he felt that I wanted to buy it and that I also wanted to buy it in bulk because a lot of people buy it. And when you look at it, it's almost the same thing as the genuine one. Sometimes it's even hard for you to know. And it says the cops come, they raid them all the time. When they raid them, they lock up the shop and they open it elsewhere. So that's also another thing to note, that for a lot of the brand owners, it's a very difficult thing to win. But what I tell my employers is, I don't want our product not to be counterfeited, because when it's not counterfeited, it means it's not top of mind. When your products, when you're a leader in a certain field or in your industry or in your field, then the counterfeiters want to sell your products because then they will, you know, it's attractive to them. So before I go on, I'll talk a little bit about my company. I'm sure you're wondering when Ololade said Halion, but I'm sure if I said GSK, lots of you will know what GSK is. So until July last year, Halion was part of GlaxoSmithKline, GSK, but the business took a decision to separate the consumer brands products from the pharmaceutical and vaccines products. So products like Maclean's took place, Aquafresh took place, Panadol, Andrews Liversol, Sensodyne, Centrum, Voltaren. These are the products that I sell. So these are the products that Halion sells. So if you don't know, look for Halion on Instagram. It's a fantastic company. It's a consumer health company. That is who I work for right now. So back to today's topic, really, when you talk about counterfeiting measures, what comes to your mind? And I'm throwing the question open again. So you do know that you have your trademark registered, you have your brands protected, and then you're saying counterfeit. So if I was coming to you to say, you want to put a counterfeiting measure in place in your organization, 2 people to volunteer, what you think will come to your mind on what you can do to protect your brands? Any volunteers, or do you want me to call? I can go through the participant list and just call 2 people. and I'll be very offended if I call you and you don't say anything. Amarachi Iwoha. When you hear protecting your brands from counterfeit, what comes to your mind? Can anybody hear me at all?
Yes, ma'am, we can hear you.
So Amarachi, can you hear me? Do you want to give it a try? There's no judging. We're all just learning.
Hello, I can hear you, ma.
Yes.
Okay.
Thank you.
Yes. When I hear about protecting my brand from counterfeiting, basically, I think it's about putting in place measures that safeguards the brand from people who may want to copy either the trademark or the business name or whatever it is that distinguishes the company from others in the market, right? I think that's what I think.
Well, you're absolutely right, and thank you for trying. So when you hear protecting your brand, and I like what you said, people stealing your brands, people stealing your rights, people infringing on your products, that's what you need to do. So I'm ultimately going to tell you ways you can do that. So I'm going to call Olusegun Idowu. What will come to your mind if you even have a product that is patented, or if you have a trademark that you've registered, or you have your own products? What do you think you can do to protect your brand from counterfeiters? Olusegun Idowu.
Okay, so let me give it a trial. Can I?
Ololade. No.
Okay.
No, you can't. Sorry. Somebody else, please. While we wait for Olusegun, there's also Oluwatosin Ojo who keeps popping up on my screen. Do you want to try? Oluwatosin Ojo, do you want to try? Look, the thing about master classes and learning, and I always say, and trust me, it's worked for me for close to 20 years. There's no stupid question. There's no stupid comments. There's no irrelevant comments. The more you ask, the more you participate, the more you learn. And for all you know, you have that thing in you somewhere. You just need to say it out. And I don't think anybody is looking to judge you here today. I'm also looking at learning. You might be helping me to find out an extra measure for what I do. So just tell me freely, like I'm just coming to you in this world of entrepreneurship. I want to protect this bottle of water that I've created from being counterfeited. What would you tell me to do? What will be the first thing that will come to you, which I'm sure that we spoke about yesterday on this program? So you just need to think. So give it a try. Wow.
I'd love to give it a try, ma.
And this is meant. Okay, Temiloluwa. Yeah, so go on. Olowo, yes, please try.
Yeah, so coming from the IP perspective, so now the very first thing I think anyone who owns a business would do is to engage in IP audits. That's coming from the IP perspective, from IP audits, for you to identify those things that distinguishes your business from those of other individuals. And once you've been able to do that, like the example you gave, for instance, you've invented a bottle of water. So that's when you now be talking, okay, what particular intellectual property is applicable to this particular product? And is then you talk about patent. So the very first step you as a business owner will take is to ensure that you find relevant ways to patent your production, which is going to serve as a very first step to help you protect your interest in that particular product. And from there, you talk about several other things. Essentially, it's about IP audits. Those things that actually distinguish your business from those of other individuals. You find a way to make sure they are registered or protected. And from there, you safeguard them from infringement from anybody from any quarter.
Fantastic. So thank you very much, Temiloluwa. You are spot on. And I see that Olusegun Idowu did type something in the chat. Maybe he was just a bit shy to talk. So thank you as well, Olusegun. So you're right. The first thing that I find in this whole thing is brand protection. What is a brand? A brand is your product. A brand is this dress I'm wearing, is this hair that I have. It's this pen that I'm holding. Anything that you've made is your brand. Whatever you sell is your brand. Panadol is my brand. Sensodyne is my brand. Augmentin is my brand. Centrum is my brand. And I know we all know all of these products. Brand protection. How do you protect your brand? Intellectual property registration. You register your trademark. Because before you do anything at all, even if it's to go to an online marketplace to take down a counterfeit of your product, which is the bulk of what we do now, they would ask you for the proof of trademark registration. You need to register the trademark. I'm not going to go into details of that because I believe we did something on trademark registration yesterday. You have to protect your brand. You have to register the mark. You have to register it in the country where you sell it. If you're a big organization like mine, then you have to register your trademark all over the world with WIPO, all over the world and all. So thank you for that. So that's what you do. So you have to register. So when anybody tells you, if there's one thing you should take away from today's session is when you talk about counterfeiting, you think about brand protection. You protect your brand. That is what you do. A lot of the big companies have brand protection teams. A lot of them have corporate security teams. A lot of them have anti-counterfeiting, intellectual property. It's called different things. In my previous job, it was called legal brand protection. In my new job, it's called intellectual property. And then there's an anti-counterfeiting function underneath it. So that's very key. So I'm going to break it down to you now into 5 different ways you can use to protect your brands and the measures you can bring to bear, in the organization. So if any of you decides to want to go into anti-counterfeiting or intellectual property, these are tips that will be useful that you can actually use to sell yourself when you're going through those interviews. So I'm giving you these for free. The first thing you need to do is to protect your brand. You need to have your trademark registered. There's a trademark registry in Nigeria. If you do like cross-border transactions, you need to get advice from the trademark lawyers to see what you can do in terms of protecting the brand. And you can register the word mark, you can register the logo, you can register the design, which is something a lot of companies are now doing. You can register slogans that you have, you can register colors and all of that. Just make sure that you cover everything. So if anybody infringes on that, you go to them and say, Sensodyne is my product. I've been using it for over 100 years. This is the trademark registration, then they can hear you. So the first thing you need to do is protect your brand, trademark registration. There are some things called anti-counterfeiting features. These are things that we look out for when somebody says, I've seen your products in the market. Can you tell me whether this is fake or genuine? Those features come in 2 forms. They are the overt features. Overt features are things you can easily look at by holding the product. So when we train our colleagues in sales that go to the field, they know the overt features to look at. It varies from the sort of way we write, how we write the numbers, whether they are typographic and all of those things. And trust me, we see these things with very poor English, with very muddled up English. We see things in an English-speaking country with Arabic language on it. These are the sort of things you see in the counterfeiting world. You need to know the overt features, and they are the covert features. Covert, as we all know, is hidden. These are things that only the technical experts can understand. So even though I've been doing this for almost 6 years as well, and I know my brands very well, I cannot necessarily by myself evaluate a product and say that that product is counterfeit or is genuine or is parallel, which we're going to come to as well. There are technical experts that are trained to do this. So in whatever it is that you do, make sure that you have the covert features as well, which the counterfeiters don't know about, which the counterfeiters cannot copy, because always remember that counterfeiting is a direct replica or imitation of the real thing. So they are going to copy everything they can see. So always keep your covert features and have people trained at doing the covert features. So when you have those anti-counterfeiting features, then those are the first thing you look at when anybody comes to you to say, oh, I think I've seen your products in the market. I don't know whether this is fake. So I used to work for a pharmaceutical company, and we all know that the pharmaceutical world takes counterfeiting to another level. Even for the consumer health that I work for, it's not like a luxurious brand or a perfume that probably will not kill you. Things that you put in your mouth, consumables, medication, you need to go an extra mile because there are adverse effects that can kill people, that can injure people. If you've been following the news last year, towards the end of last year, the WHO found some cough syrup in Gambia that killed over 72 children. A lot of companies were involved. I was closely involved in that investigation as well, because children died. So if you find yourself in a pharmaceutical company, in a Unilever, in a company where they make food, just make sure that Procter & Gamble and all those places, you take an extra care in terms of protecting them, because people might die. And if somebody dies using your product, then you're liable, you know, because if you don't warn your consumer. So the next time you buy something, a Sensodyne toothpaste, Maclean's toothpaste or anything, you need to look at the packaging, and you would see that there's an address where you can write to if there's an issue. There's always a consumer care line that you have on the pack. That's an overt feature board. I mean, it's for consumers to be alarmed, to be warned that this can happen. So anti-counterfeiting features, I've said. Trademark registration, I've said. Again, you hear counterfeiting. Okay, I'll come back to that. The other thing you can do is something called border protection. We've all seen those movies about border protection. I mean, I always joke that if I was not a lawyer, I probably would be working with the MI6, you know, because I like investigation. Is a big part of what I do. You know, I do a lot of investigation. I like all those James Bond movies where you go undercover, you protect people and all of that. Border protection, so it's not that kind of protection. Border protection means that safeguard your products before they get into a certain market. So for a lot of big companies like mine, we don't necessarily produce in the country where the products are consumed. My company has operations in over 150 markets. I cover over 100 of those markets, and we move things from different places. Yes, we have the factory in Nigeria, Agbara, but we also move a lot of things from the UK and Egypt into Nigeria. How do we do border protection? Custom recorder. I am hoping that sometime in the near future, Nigeria will have a recorder process in place, because we don't have anything like that. What does a custom recorder mean? It means there's an online portal where you register your trademark with the customs to say, if these products are coming in and they are not from the authorized country of export, please hold on to them. They are not my legitimate product. You have the right to look at them and get back to me. The only country that had it formalized in Africa for a long time has been South Africa. Egypt has it, but it's quite informal. It's not very formal. Kenya just launched it last year, which I think is a welcome development. I'm hoping that Nigeria would have it. When I talk to my colleagues in the IP world and some of you, I think that's something we need to work on, because it's always an easy way to have the customs to be proactive. So what we do is we have a recorder portfolio where we record our marks with customs in all the countries where this is operational. Training, capacity building, engagement. So when I was covering Nigeria, I had a lot of relationship with NAFDAC, SON, customs, and the police. If you're in the world of brand protection, you can't do it without customs, you can't do it without the police, you know, you can't do it without the regulators. NAFDAC are the regulators in Nigeria. For every brand that you sell, for every product you sell, I'm sure most of us know that you have to get the permission from NAFDAC to sell them for the drugs and food. So you get a license from them. SON are the ones for non-drug related ones. So these are the people you need to work with. Your border protection has to include having a contact person in all these agencies, having regular meetings with them, having trainings with them. For any of you that is interested in become an anti-counterfeiting expert, there's an association in Nigeria called the Anti-Counterfeiting Collaboration, ACC. You might have heard of it. It's really great. And they talk a lot about brand protection and all. So if you're interested, you should join that as well. Look for them. Border protection. So we do a lot of trainings for customs. So what do you tell customs? Know my brands. Difference between counterfeit and genuine products. Know where I'm shipping it from. Know my route to market. It's quite extensive when you put those trainings together, because you're telling them I manufacture in Denmark, I ship through the UAE, I bring to Nigeria. Supply chain integrity will be the next one, but you need to have your allies in customs, NAFDAC, if it's Nigeria, the police, and then the SON, depending on what it is that you sell. And you need to devote time to train them, not just having, I mean, yes, post-COVID, we've had a lot of virtual, But I think the face-to-face training has been really good. And for the big companies, you just factor this into your budget. You know, you meet with them, you engage them, don't bribe them, because every multinational has an anti-bribery and corruption policy, because I'm sure that we know that if a subsidiary is found guilty, it affects the bottom line of the parent company as well. So you need to be close to these people. I've talked about the trademark registration. That's number 3 points. I'm going to ask you, but I'm going to go over it again. Trademark registration, features, border protection. The 4th one is supply chain integrity. What is supply chain? Supply chain is moving your products from the point of manufacturing to the end user. So the ideal world, you move it from the manufacturing side to the warehouse, from the warehouse to the distributor, from the distributor to a wholesaler, from a wholesaler to the consumer. So look at how interesting all the work that we do for you to get that beautiful, lovely Sensodyne. And I hope that that is all you use, Sensodyne, Maclean's, or Aquafresh. If you don't, well, you're on your own. You need to get one of those toothpaste to brush. So basically, that is supply chain. How does this help you protect your brand? You are able to track every single batch number that leaves your facility. So for every product that we make, there's a peculiar and unique batch number on all of them. There's a manufacturing date, expiry date, and batch number. So if you were to come to me to say, Adefunke, I found your product in the market, I'm going to be asking you, send me the batch number, send me the country of manufacture, send me the manufacturing date and expiry date. I have guys that are that are in the factory that can check it and tell me within 24 hours. This was produced by us. These are the countries we exported it to. These are the volumes that we exported it to. So when I tell you that my world is quite interesting, it is, because I'm living my MI6 in a different way. Because when you hear all of those things, you get into the details of how many pieces did you ship out, what countries did you send it to, tell me the route to market. Route to market is simple, it's from manufacturing to the end user. So supply chain integrity is really key. You need to be able to do that as well. And most of us, if we're lawyers, investigations, you have to be proactive versus reactive. So for a lot of companies, they take the reactive approach because anti-counterfeiting investigations is very expensive. You pay in dollars, you pay in pounds. You chase a criminal world that you never find. So what happens? 95% of the products that are fake come from China. The remaining 5% come from India. But most companies get this China problem. That's where they come from. And you need to be proactive. So if you're going to launch an investigation in China, you can imagine how much you're paying in China. And China is as corrupt as Nigeria. So you have to be sure who you work with, not to be acting in contravention of your anti-bribery and corruption policy as well. Even when you launch investigations in Nigeria, there are some lawyers that I see in the house. You don't come cheap, you charge us, you have to pay for those investigations. The business wants a return on their investment. They want you to nab the bad guys. They want you to lock them up. They want you to shut down the manufacturing side. We succeed sometimes, but many times these people are dead-based. They don't even tell you where they're getting the products from. So you'd go to the cybercrime departments as well. You go and get things like their laptops, their email addresses. You do surveillance. These are quite interesting. So you need to be proactive as well. I have investigators that I brief. I have external lawyers that I brief. Why do I need them? Being a lawyer myself, I'm not an expert in every country. I don't know every country law, even though I'm Nigerian. Yes, I understand the Nigerian intellectual property law to a reasonable extent, but I still need the experts that are up to speed with this for them to work, and then support. And I'm not in Nigeria, so it's not that easy. And for all the other countries as well, you have to partner with these people. How do you do these lovely investigations? We call it a market survey. A market survey is you get investigators to go into the field, to go and pick samples of your product. That's test purchase. Test purchase means they go into a shop where you suspect are selling counterfeits. They pick a couple of products. They send it to you, whether the images or the actual sample. You do an evaluation. You come up with your result. If these are counterfeits, then your investigation gets to level 2. Level 2 means you're going to NAFTA to say, I found the shop in Owerri, in Abia, in Kano, in Kaduna. I've seen counterfeits of my products in all these markets, by the way. And NAFDAC has been quite supportive. I want you to go in there because you can't raid yourself. You can be arrested. I want you to go in there, raid them, clear them off the things, and then let us start the prosecution. It takes years. I have a case that has been on for 8 years and we haven't even finished. The person abandoned it and we can't find the person. So you need to do a lot of investigation as well. Market survey, test purchases. It starts with targeted identification as well. So your sales team are the ones that would identify the targets, and then they come to you. Then you start to build it from that level up, and up. But don't forget, work with your external lawyers, work with your private investigators, work with your police, work with your NAFDAC and the like, and get it moving. Then you get to enforcement. Enforcement is when they actually go into the field, and they do quite a lot of work. You'll be amazed. You know, they go in there, they survey it for like a day or two, then they just go in with their uniforms and all, lock up the shops, raid the products, put them in storage. Actually, they do some arrests. Yes, they're entitled to bail, and then prosecution starts from there. But there's also the reactive one, which a lot of the big companies are doing, because proactive investigation is very expensive, and many times you don't get the bad guys ultimately, or in a lot of countries, the sanctions are very little. They pay the sanctions and they go. But in countries like the UAE, they do have an administrative procedure where with the DED, Dubai economy, where they can actually withdraw their license to sell. You know how they are in those Arab countries. So those also work, something that Nigeria will get to, hopefully. Tip is you don't do anything until somebody tells you that they found your products in trade. Then you start to ask the questions. Then you start to follow those proactive steps. But you're a bit too late because it's already out there. You didn't do your border protection to protect them from coming into your country. They're already in your country, you know, and it's already in the market. And your reactive would then be case by case, you know, get your lawyers involved as well. When you have a strong case, build it against them, start the prosecution. Litigation is quite important as well. I'm sure most of us have heard about cease and desist letter. Can somebody tell me what a cease and desist letter is used for under intellectual property law? Just try it. Hear the name, cease, desist. What comes to your mind? Have you heard it before? Even if you haven't, just tell me, no, I've never heard that before. It's fine. Radiance, oh no, you just popped up. Oh, you were actually trying to talk. Fantastic. What is a cease and desist letter? You can type as well. It's fine. Useful. I hope I'm not boring you with the world that I live, but I think it's the best world. I really enjoy it. I've done it for almost 6 years and I'm not tired. Radiance, you want to type? Does any other person want to try? When you hear of a cease and desist letter, what is this used for? You might be needing it.
Oh, I think some people are raising up their hands.
Oh, sorry, I can't see. I'm so sorry. Can you help me? Okay. Okay, so I think that's Olusegun. Said it will stop infringing. Exactly, no more infringing. So you cease infringing on the product, you desist from trading in that thing. So a cease and desist letter is the first step in actually dealing with this when you find a target. So you send that letter. Most times you get your external lawyers to write it, because what you also need to do is to protect your own people. If the counterfeiters know that I'm signing that letter for my company, they might look for me. We've had that in Pakistan before, and we started to, you know, stop those things. So a cease and desist letter is one thing that you should all learn. If you want to do intellectual property law, you need to be able to write. It's very clear and straightforward, but can somebody tell me the first thing that you need before you can write a cease and desist letter? What gives you the foundation to be able to write a cease and desist letter? Anybody? Very simple.
Okay, so Mr. George is raising up his hands.
So Mr. George, what do you need to issue a cease and desist? What's that first thing you need?
Well, in my opinion, I believe first thing is you need evidence of maybe pictorial evidence of it that you can use to confront this person, because yes, telling someone, if you're telling someone orally cease and desist, the person might want to take it as, okay, maybe you are maybe making false accusations, that kind of thing, and they might want to turn it into like a counter suit or so. But if you have evidence that you can attach, of course, and you can say, look, we have this, and then we can take legal steps against you because we have this legal rights. We have that we are enforcing, which is why we are sending you the cease and desist. So once you have that, you know the extent and limitations of that and how well you can use it against the person, then you can identify all of that in your cease and desist letter, and then you send that. And also, as you highlight for security purposes, you might just use, okay, the company signed the company, rather than outing the person who drafted this and this letter, because you never can tell. People are desperate. So that is my opinion.
Okay, thank you, Mr. George. Season, evidence, yes, but that's not what I'm looking for. That's not the first thing you need. It's part of what you need, but that's not the first. Who wants to try? But yes, it's very important. You need to have your evidence. So you don't base this thing on assumption. You have to have your facts, which is also what you should tell your employers and your sales and marketing team. Give me all the world where they are selling it, but I need facts to be able to do that. But there's something that gives you the right to be able to issue a cease and desist letter. That's what I need. Who wants to try?
Okay, so Amarachi is raising up her hand.
Amarachi, yes, please.
Okay, I believe as a lawyer, before you can write a cease and desist letter, you need to get an authorization from the client. I mean, the one whose goods are being counterfeited or
okay, so you are close. So you get a power of attorney, that's external. The person whose goods are being counterfeited, what right does that person have to say those are my goods? That's what I'm looking for. Who wants to try it? So they are your goods, I know. What right do you have to say that they are your goods? We talked about it. That's what this whole program is about.
Okay, can I give it a try?
Yes, please.
All right, so first and foremost, you must prove that that particular thing has been registered, that you have legal rights over it.
What sort of registration? What is that legal right?
Yeah, depending, probably if it's maybe someone, it can come through patents, copyright, like we have the registration of that particular product that you registered.
Okay, so I'll give you a pass. Fantastic. Who just said that? That's what I've been looking for. Trademark registration, that's what you need. Whatever you do, you need your trademark registration. You're going to Facebook to take down a fake product, you need your trademark registration. You're going to Alibaba, you're going to Instagram, which we do a lot. I take down a lot from Facebook and Instagram every month. I have a team that does online enforcement. So you need your trademark registration. And like I said earlier, whatever you do in the world of counterfeiting, trademark registration is the first step. You need to register your trademark. Yes, patent is good, but not all of us have patented products, because you know how patent is first in class. After a while, then it's open. There can be, now what do you call those things? Skip my mind. There can be when it's not a brand, I can't remember that word. Then there can be other people. So like Panadol was patented, but there are lots of paracetamol that are not Panadol after the patent period was over. So trademark registration is what you really need. Thank you very much for that, Olusegun. If you were a woman, I would have offered to take you as my next cohort of mentee, but unfortunately, you're a man. Anyway, not that I'm being biased, you know, but it's just what I'm working on. For maybe in future, I would also work with the men. So that's what you need as well. Another thing is you need to be very active in terms of your industry association. So I did mention ACC. There's also IACC, which is focused on America and some of the countries that react. There are also the you know, there are all these associations that you need to be part of, because sometimes you can work together collectively with other people in your industry to address these things. Inter is one that is very good at lobbying as well, because sometimes you want to lobby. I know before I left Nigeria, we've been trying to work on the IPCOM bill for a very long time. I haven't heard that it's been passed into law, but those are the sorts of things. This sort of IP discourse group, you find other people that are in your world. You just need to be visible. You need to grow your network, not just for intellectual property, not just for counterfeiting, for anything that you do. You need to learn to grow your network. And at the end of it all, know that you have your trade secrets hidden from all of this. You have your brand protection. You've taken all the necessary steps, and you're there to take the proactive steps when you need to do it. When somebody looks at your product, put your trademark statement on your product. Let them know that it is yours. Put a contact number on your products. Don't forget your covert and overt pictures. Don't forget your trademark registration. Don't forget your border protection. Don't forget your supply chain integrity. Then you get to your investigations and litigation, which I'm sure that we all like. So question and answers. I hope that you've learned a few things from today and you're in a better position to protect your brand going forward. So I'm happy to take some of your questions. Thank you.
All right, thank you very much, man. So it's been quite insightful the way you've actually been able to take us through the nitty-gritties of what anti-counterfeiting entails, not just within Nigeria, but indeed outside Nigeria. So please, if you have any question, there are no questions in the chat box now, but if you'd like to use the mic, you can signify request mic, so you give the chance to ask your questions. But pending that, I have a question now which borders on corruption. And the question is this: would you say that corruption among law enforcement agencies as allies to the perpetrators of counterfeiting is a major factor that promotes counterfeiting in Nigeria or indeed anywhere in the world? Is corruption amongst the LEAs and those who perpetrate counterfeiting, is that a major factor, man?
So I wouldn't really say it's contributory. It's not a major factor. So it's contributory in the sense that, and I actually did have a case in Nigeria where my products have been released. Till today, they're telling me it's not been released. But I know that it's been released because it was a police raid. We didn't tell NAFDAC because we didn't want NAFDAC to waste time. We got the police raid. We moved it to storage. At first, they said NSAS happened. After NSAS, COVID happened. Till today, they keep telling me your products are in storage. Nothing has happened. I know that they must have released it to the counterfeiters. So it's part of the problem, not just in Nigeria, in a lot of African countries as well. There are some countries in Latin America where they will tell you to your face that there's a market I can't go to. I'm facing that challenge. If I go there, they're going to kill my men. And I know that they do steal this thing, so they can. So it is a problem, but that's also where when you have a plan, it comes to play, because we don't bribe. We've never bribed to do anything. We still get work going. The only thing is, instead of bribing, what we do is to give letters of commendation to the officers that have supported us, to go and train, to support them, to acknowledge them and things like that. But yes, it's one of the things that are stopping it, because the reality with counterfeiting is that you're dealing with people that have organized crime chain. Half of the products are not manufactured locally. They are being brought in from China. These are people that have money, to make these things in bulk, and they are shipping it in. So they don't want you to stop them from working. So corruption is a major issue, but not just in Nigeria, in a lot of the third world countries as well. Yeah.
All right,
and another thing with Nigeria is, I know we do have some laws on intellectual property. I think I'd come across a regulation before. It wasn't a full law on anti-counterfeiting, but there's nothing that actually prescribes the minimum sentence for a counterfeiter. So even when you take them to court, it's at the discretion of the judge. They are busy with other things. They strike today, tomorrow, and everywhere. They will keep canceling and re-adjourning the cases and all of that. In the IPCOM bill at the time, I think there was the part that dealt with counterfeiting in a bit more detail, but I'm not aware that that has been formed into law till now. So that's also something. The regulations need to be improved, and there needs to be specific sanctions and for things like counterfeiting, because it's a major problem affecting all of us. Yeah.
Thank you very much, Ma. Yeah, in the absence of any question, we swiftly move on to the next speaker now. But indeed, we really, really appreciate your presence here, Ma. And I personally, I'm looking forward to when you are going to organize a special program for the men, so not just the...
Okay,
exactly.
No
Yes,
problem. It will be in the near future. Yeah, all right. Thank you so much. Yeah.
Thank you very much, ma'am. All right, so moving on to the next speaker, in person of Mr. Olusegun Oyesanya. Now, I'll be reading out the citation now. Olusegun Oyesanya is a legal counsel at Run Money. Please, can you confirm if you can hear me, please? Can anyone hear me?
Yes, I can hear you.
All right. Yeah, Olusegun Oyesanya is a legal counsel at Run Money Microfinance Bank, one of the leading tech-driven lending institutions in Nigeria. Segun began his IP practice in the intellectual property department of Jackson, Etsy, and Edu, where he assisted in managing the IP portfolios of foreign clients in over 30 African countries. Segun advised several multinational brands on the registration and commercialization of their IP portfolios in Africa. This also included conducting specialized IP audits, researching innovative brand protection methods, drawing up legal instruments, and advising on licensing of franchising. Segun's 5 years experience in the legal profession is heavily invested in IP, as he is also an overseas member of the Chartered Institute of Trademark Attorneys and has written expository articles on IP protection in Africa. When Segun is not working, he's either hanging out with friends, watching a blockbuster action movie, or a Chelsea FC game, or playing video games. And of course, I would say up Chelsea now, but then we know what Chelsea is currently going through. So indeed, thank you very much for joining us in today's session. The floor is yours. You can start the session, sir.
that was a shade against Chelsea, right? Anyways, today is not for banter. Good afternoon, everybody. Please, can you confirm that you can hear me?
Yes, I can hear you, sir. We can hear you.
Okay, all right. So I would like to share my screen, even though it's still going to be very, very interactive. Just like the last speaker, I had a session very interactive. That was really, really awesome. Okay. Just a second. I hope I can share. Victoria, please, can you enable me to share?
Yes, you can share now, Segun.
Okay. All right. Please confirm if you can see my screen, please.
Yes, I can.
All right. So I'll be talking on licensing and assignment for trademarks and copyright. And thank you for the introduction. And thank you, Victoria, for inviting me to talk to everybody here. It's quite a privilege. So licensing and assignment, I'm pretty sure some of us might have come across these two words in the course of our engagement with IP. Well, my assumption here is that most of us are not lawyers, or let me say half of us are lawyers and the rest are not lawyers. So I'll try to be as basic as possible so that everybody can understand what is being said. So of course, both terms belong to a broader term called IP commercialization. That is, you're trying to commercialize your IP portfolio, you're trying to make money from it. Right, and under licensing, you have merchandising and franchising, even though people try to categorize it differently, but basically still the same. It's still under licensing because you still retain some kind of rights, or unless you are signing. There are spin-offs, there's securitization. So those are different ways you can commercialize your IP portfolio in Nigeria and other countries of the world. Okay. So for licensing, yes, I call it an art because why? Because there's an art to it. When you say you want to license the rights, when you say you want to make something available to others, right? It's like a lending, like a concept where you are lending something to somebody, right? And then you're going to get it back at the end of the day. That's the most important part of it. Either you are still you can lend it to so many other people, or but the most important fact is that you are still the owner at the end of the day, right? So that's the most important part of licensing, and that's the difference between licensing and an assignment. An assignment, you're letting go, right? It's a sale. You're assigning your rights, your legal rights in that asset, in that property, like bye-bye forever and ever. But for licensing, yeah, you're still the owner, and you can either choose to, get some form of compensation for licensing, like maybe that's what we call royalties, over and over again, maybe yearly, monthly, quarterly, depending on your arrangement with your licensee. So there are different types of licensing, and the answers are already on my screen, even though I would have loved to take answers from people. But okay, let me just do this. Can anybody just explain to me what's the difference between exclusive license and sole license? Anybody at all? I hope I can see the answers here.
Yes, Segun. If there's anybody that wants to explain the difference between exclusive license and yeah, if you want to answer the question, really, just raise your hand so that you can speak. Or if you like to drop it in the chat box as well, just
That also works.
drop it in the chat box too.
Okay, I think I can put it. I hope this chat box is not covering my screen. Can you see my screen fully?
Yes, I can see your screen.
Okay,
Okay,
all
so
right.
Mr. George wants to say something.
Okay, thank you very much.
Yes, so I'm just going to attempt, not saying I know it. And so for exclusive licensing, the nature of the license is such that you're agreeing that I can only license to you alone, like it's a contractual agreement. I'm saying I'm licensing to just one person and that person alone. So that person, if I'm going to be lending to anybody, I'm going to lend to only that person the IP rights. But sole licenses, where say on my own volition, I decide that, you know what, I don't want to have many people I'm lending my rights to. I just want to just pick one person and okay, I pick you and I'm lending to you. Not because, of course, I want to necessarily reach myself, but I just maybe want to have it cleaner and much more simpler to track. And maybe I can always say, you know what, I don't want to license again to you. I can license to another person, one person at a time. But exclusive, I'm saying nobody else. If it's not you, it's not anybody else I'm lending to. So that's my explanation.
Thank you very much. Thank you very much, Judge. I think some people else raised up their hand. Can you just can you just allow them to speak? Maybe just one more person and then I go to the answer. I saw somebody else raise up their hand.
No, I think it's only George who raises hand.
Oh, okay. Okay then. So, well, thank you very much, Judge, once again. But that's very correct, except for a little bit of how do I say it, amendment on your definition of the sole license. So, an exclusive license, the way it functions is it functions more or less like a territorial license, right? So, when I say I want to distribute, for instance, I want to distribute, let's say, fans, electronic fans, like, let's say, international makers like Ox or Binatone, and then I want to distribute fans in Nigeria, and then I look for an exclusive licensee, someone that is just going to be that person to the exclusion of all others, right, in Nigeria. So he is the owner of the exclusive license for Nigeria. But in Kenya, I can look for another exclusive licensee. But when it comes to sole license, in all the countries in the world, for all your rights, and you see that as you go on, there are different kinds of rights, right? So someone can be an exclusive licensee of a particular kind of right. Let's say the right to make the blade in the fan, right? That's just the exclusive license that person has, and someone else makes the engine and all of that. But when it comes to sole license, that licensee controls all of the rights in every place, right? So that means that person is just like how do I say it, your attorney in fact, that is like your representative, your someone else that just stands in your place. So you move away from the liability and the person just makes the money and all of it. And we'll see examples of that as you go on. So there are other modes of licensing. There is sub-licensing, that is a licensing that licenses to another person. The market is really, really large when it comes to licensing. It's crazy. Like there are so many moving parts, and you will see all of that. I just want to rush for time. There's also what is called cross-licensing. You see a lot of cross-licensing in the tech industry. That is, somebody has a patent, for instance. You see a lot between, let's say, Samsung and Apple, you understand, or Samsung and Adobe Acrobat. So they have a patent license, a license to a particular manufacturer. Sorry, manufacturer licenses maybe its product to Samsung, and then Samsung also maybe to Nokia or whatever. The same company, there's a cross licensing, one patent license in exchange for another license to make different things. So that's cross licensing. So there's a lot of moving parts when it comes to licensing. It's actually very, very big market. So I decided to source out this kind of protocol or this kind of strategy that most organizations use, to go to the licensing market, they locate prospective companies for licensing, they pinpoint the strongest, they start from pinpointing strongest IP for commercialization, right? They create profitable products from that. Then they locate prospective companies for licensing, and then they quickly enter new markets. So that's just the characteristics around licensing. All right. Please, if I'm moving too fast, just call my attention to it so that I can just rewind a bit. So the concept of an assignment is it's a sale. You're disposing your rights in an IP asset. Let's say, for instance, and I want to come down home, right, to SMEs, things that we do here in Nigeria. Okay, so let's say, for instance, you write a poem, right, and then a company abroad falls in love with your poem, and then they say, oh, can we buy this poem? Can we buy? And then, they come, and then you're excited. They want to pay you in dollars, $500 for my poem. I just wrote it. Wow. Right? And then you send them the poem and say, oh, no problem, send me the $500. You collect it over PayPal, or they wire it directly to your bank account. So that's an assignment. You don't have the right to use it anymore as your own, because they told you they want to purchase your poem. That's different from a license. So let's say, for instance, now they say, oh, we just want to use your poem. We want to put it on our shirts everywhere in Ghana, for instance. It's going to make a lot of sense to the Ghanaian market. They're going to buy our shirts. Please, can you give us a license to use your poem in Ghana? That's a license. And they can also buy your rights, right, to use that poem in Ghana. So, but just understand that the difference majorly is that for a license, it's like you're lending it out, you're still the owner, you're just giving out for a period of time, right? But for an assignment, you're selling totally. So things to consider, just normal contract relationships. I don't want to go into this since you can see my screen already, and that's the purpose of the screen, so that, and then you negotiate. Let me explain what IP due diligence means. So IP due diligence is for you to go back to say, okay, let's say you want to buy, let's say the company that is excited in your poem, they want to really buy the rights in your poem. And then they ask, okay, how did you come about this poem? What they are doing there by asking that question is what? Due diligence. They want to know whether you are truly the owner. So let's say, for instance, now you now say, oh, wow, I didn't just write all the lines of the poem. I wrote about 8 lines. Let's say it's a sonnet. I'm sure the literary gurus in the house will understand what I'm trying to say. So sonnet is a 14-line poem. So I wrote 8 lines, and then my other friend that we're friends together, she wrote 4 lines, but we're just in the heat of the moment and all of that. So what they are trying to do there is what? IP due diligence. Because by the time you are giving them the rights, your friend that helped you to compose the rest of the 4 lines can come and say, oh, wow, you never consulted me. You got $500. There's a proverb in Yoruba for that. It says when it comes to money, that's when friends they fight. That's what happens when you conduct IP due diligence. So you try to know exactly who owns the rights to these IP assets. So, and then before then you go and negotiate and draft contractual terms, and then you also perfect the title. To perfect title, right? Like the last speaker spoke about a lot, means to go and register at the regulatory authority to make to perfect your title, to register your title in the new name of the name of the new owner. Okay, I want to move faster. Just bear with me. So licensing trademarks. I already explained what the concept of licensing is, so I think we can move faster. So in trademarks in Nigeria, the word there in the Trademarks Act is not a licensee. You find the word registered user, but essentially has the same impact. So that means that a registered user is like, it depends on the kind of license you have, whether non-exclusive, exclusive, or you're sole licensee. And then you have to submit your contract before the registry to get registered. And the law recognizes you as a licensee under the law. Now, do you have to register all the time you're licensed for a trademark in Nigeria? You have to register. You're not compelled to register, right? But there are disadvantages for not registering that license, right? Let's say for a company that wants to use a product in Nigeria that was licensed for a product in Nigeria and then was not registered as the registered user in the trademarks registry. Number one is the fact that the person cannot bring a legal action. Let's say that someone else is now infringing on that trademark. The licensee, that is XYZ Limited, that is in Nigeria, cannot sue the other, cannot sue the person infringing on the IP right. He has to wait for the, let's say, the multinational that licensed him to come and bring a suit against the infringer. So those are one of the disadvantages of not registering your license agreements in Nigeria. So there are contractual terms, and this is particularly for lawyers. Even non-lawyers can just look at this in them, but essentially always get an IP lawyer to look at this for you, or else you might run into trouble. So there are contractual terms for you to look at, whether it's exclusive, whether it's sold or non-exclusive, the territory, right? For instance, if you have territorial license for West Africa, that is the whole of West Africa. If you go beyond that part, they can revoke your license, right? The royalties that will be paid, the tenure, the duration, actions that constitute breach. For instance, you use, let's say you're licensed for, Toyota owns Lexus. So let's say you're licensed to use Toyota Prado, just that name, and then you begin to use Toyota Corolla. That's a breach. They never licensed you to use that trademark, the Corolla trademark. So that's a breach. And then the cost of registration, who's going to bear it? Is it the licensee or the licensor? The licensor is the person, is the owner, the person giving out the license rights. Again, if you don't understand the terminology, just type in the chat box, I'll go right again. So I did a kind of case study to help you understand assignment in trademarks, and there are still more examples like that you will see. Okay, so I'm using Nike as a case study because it's very popular. So Nike, right? Who owns Nike? Nike Incorporated. You can check that up. So the title is that they are registered, they are registered before the trademarks registry. That's what it means as a registered owner. Common law means that even though you are not registered with the trademarks registry, the common law rights will still, you will still have common law rights. And what does common law right means? That let's say someone else uses your mark, right? You can still sue the person, but you will only be suing the person for what is called passing off, not for infringement. That's passing off. These are just technical terms in law. Sorry to the non-lawyers here. So what are the rights that you have, that Nike has over its own mark? That is just whether it's logo, its trademark, trade names, all of that. It has the footwears, right? The clothes, the accessories, they are registered in classes 25, 18, 35, and they have rights to the Nike mark all over the world, right? So that means that if they are assigning to XYZ Limited, right, they are assigning legal rights. That means that they are saying bye-bye. Now, I made the distinction here. I deliberately did not include footwears and clothes. That means that Nike can choose that, okay, for Nigeria, I'm not assigning my rights to produce footwears and clothes. I'm only assigning my rights to, let's say, XYZ Limited, just to produce accessories using the Nike trademark, to produce perfume using the Nike trademarks, right? So those are ways companies make money, and there's a lot of money from this. Trust me, there's a lot of money that comes from assigning these rights, and we'll soon see all of that. I have more relatable examples. So rather than just say, okay, I want to assign all the trade, like all my trademark rights in Nike trademark across the whole world, I just want for Nigeria. I don't want for, and the same thing happens. I can license someone for just Lagos State. I can assign trademarks for just Lagos State, and then tell the person must never go near Oyo, Abuja, Port Harcourt. So you can see that there's a whole lot of moving parts when it comes to IP assets, and that is actually why companies are worth billions in the world. I mean, their trademarks, their IP portfolios, they are worth billions in the world because there's a whole lot of moving parts that you can use your IP to do. I know that. Okay, let me leave that out. So for copyright licensing, right? These are basically all the rights that you get in a copyright. These are copyrightable works, your literary works, that is novels, your poems, they are all regarded as what? Literary works. Musical works, they are manuscripts, compositions, and all of that, So there are also sound recordings, digital beats, audio tracks, broadcasts, cinematograph works, which are what? Your movies and music videos. So that these are all the rights you will find in each one. So let's say there's a novel, you will have all of these rights in that novel. If there's a sound recording, let's say someone makes a beat, a DJ makes a beat as a sound recording, you find all of these rights in that single beat. So that means that the person can decide to license reproduction rights and decide to not license distribution rights. The person can decide to license adaptation rights to company A and license broadcasting rights to company C. So it works in like so many ways and all of that. So okay, yeah. So I have some examples for copyright licensing. I believe 90%, let me assume, let me just be on the safer side. I said 90% of us know what the movie called Game of Thrones, right? And of course, the HBO is the company that is producing it as a movie. But guess what? They don't own the copyright to that, to the original work, which was developed by George R.R. Martin, which is A Song of Ice and Fire. Some of us have read the book. So, and then we'll see that what we have there is that the HBO were licensed, were given license to adaptation rights. So just like, let me just ask, what other rights do you think that can be licensed there? Let's say, for instance, now, Ebony Life Productions wants to do something on George R.R. Martin work. What other rights do you think can be licensed there? Can anyone help? Who wants to help out? Oh, sorry, NEPA has acted up. Sorry, can you hear me? Hello?
Yes, I can.
Okay, is there anybody helping us out? I feel like I'm a lot fast, but we are pressed for time.
So if you like to speak, just raise your hand so that you can speak.
I would really love us to talk about this one, since this one is more relatable. Ebony Life Productions wants to do something on A Song of Ice and Fire. What other rights do you think? Okay, let me go back to the previous page. What other rights do you think that they can get from George R.R. Martin licensing? And give the example, like what can they do? Thank you.
Okay, somebody is raising his hand.
Okay.
Okay, please go ahead. If you're raising your hand, please go ahead to speak.
Animated series.
Sorry, your network is not making me hear you well. Or can you type? You can type it in. Does anybody want to help? Anybody at all? Or do you want me to look for participants just like Adeyeye? Anybody else want to help? Ebony Life wants to do something. What do you think they can? Oh, okay, let me not say Ebony Life. A company in Nigeria wants to do something on George R.R. Martin's work. what do you think? What other right do you think they can get for Nigeria? Nobody's helping me. Wow. Just go ahead. Oh, fantastic. See, animated series, right? So what kind of rights would that be? That would be another adaptation, right? They are adapting one work to another work. So an animated series, yeah, fantastic. Performance rights and distribution, yes. Performance rights, and let's say, for instance, they want to use it to, they want to do an excerpt and make it a drama or a play, right? And they are going to perform it. Fantastic. They can do that. Distribution, yes. Yes, that is fantastic. That is perfect. Distribution in Nigeria. That is, they want to distribute the books, not the movies, the books in Nigeria. Okay, let us move on. So, and guess what? As HBO is a licensee for the cinematographers, they can also sub-license. And for television rights, that is broadcast, you are now watching on HBO TV, or maybe you can sub-license to Netflix, that's broadcasting rights. Merchandising, you can now begin to see your favorite characters in different, maybe toys and all of that. There's a musical license, there's gaming license, so much to do in the world of licensing. And that should also bring it home to your own work. Whatever you do, like, it should give you an idea of what your IP is worth. So it's not every time that, let's say you create a very great IP, don't always think that the best way you can profit from it is to assign it, is to sell it off. No, sometimes you can just explore licensing and say, okay, I want to make more profits from this. Trust me, Jaja Ramati is a rich man for life. I'm not joking, no jokes on that. And you see from the next slide, I have someone that has made quite, yes. So this is another shade of it. It's almost the same thing, but there is a difference. Almost the same thing, but there's a difference. So I'm pretty sure everybody knows Harry Potter. At least you must have heard about Harry Potter. Even if I've never watched the movie. I've never read the book, but I know about the IP rights, coincidentally. Okay, so J.K. Rowling, of course, everybody knows that that's the author of Harry Potter, which is a literary work also, by the way. So this time she did not license. She sold off the film rights, which is adaptation rights, just the film rights. So even here, I think there's a need to even correct that, because she didn't sell off all the adaptation rights. She only sold off what? The film rights. That is the right to make a film from a book. So which means that someone else can come up and, like Blessing said, do an animated series from that. So there's so many moving parts when it comes to licensing, and this is for copyright. We've talked about trademarks, and that's a registered user. You can get a brand, Chicken Republic, KFC, most of them, they are licensed brands. That's for trademarks. This is for copyright here. And what's the difference between both? If you were there yesterday at the sessions, you'll have learned the difference between trademark and copyright. So I'm sure when many of us that are employees, you are also giving employee contracts to sign, and you see that there's an IP assignment clause. That is, whatever you develop in the course of the business, you are assigning that copyright to the company or to the firm. So that is another way of copyright assignment, where assignments comes in our day-to-day activities. Okay, so I'm almost getting to the end. I decided to just do this slide on valuation royalties, because there's almost no way you want to talk about licensing and agreement, which is about IP and commercialization, and you're not talking about valuation, how to get your royalties, revenue sharing agreement. So there are different ways to value an IP asset, to know what your IP is worth. There's the income method, there's the market method, there's the cost method. So basically these are, like, should I say, I don't think they are valuation terms. I don't want to say they are accounting terms. They are valuation terms. Income method is simply, okay, how much am I making from this IP asset at the moment? For many of us, maybe if you are a music person, let's say you are making songs and all of that, okay, how much are you generating per month, per year on your IP assets when you want to sell it or you want to license it out? So it gives you like an idea of how much you can now sell your IP. And okay, I'm not talking about patents. Let me just restrict it to IP. So there's a market method. Market method is to, go into the market, similar IP assets, try to find out, okay, how much are they being sold for? How much are they being licensed for? Then gives you an idea of the valuation to put on your IP asset. And these methods are so important. IP valuation is so important so that you don't overprice your IP asset and then lose investors or buyers or licensees. And it also helps not to underprice, such that you're not losing out or when you should actually be gaining. Then going to royalties, because your valuation is going to affect, if you're going for licensing, then it automatically means that you are also going for royalties. This is another part where you have to be careful, you understand, to know which way you want to charge your revenue. You want to use a flat rate, let's say 3% per annum of the total sales, or you want to use, a flat rate is that you say that, okay, you are going to pay me 1 million per annum. Sorry, that's a flat rate. And you see that in most technology agreements, they just tell you that, okay, for using our software in your organization, you're going to pay us 1.5 million, you're going to pay us 3 million. I do a lot of agreements like that today. And then, you just see, they just put, okay, this is the amount you're going to pay us. This is the amount you're going to pay us for using the software. And then there's a percentage based, which is what I said earlier, let's say 3%, but majorly most percentages, they range between 3% and 15%. Going higher than that is more or less, you're not going to find a licensee. So you look at that, and what does percentage means? That means that if the sales increase, of course, you get more cuts. If the sales flop, let's say there's a COVID year, then you're in for it. But a flat rate, you always get that, whatever the sales performance is in the market. Then if it's a lump sum, that means that you're saying, okay, I'm not getting it per year. I'm going to license for 5 years, and you're going to pay me a lump sum of 500 million naira upfront. I'm not going to charge you again. You're not going to see my fees again until after 5 years. That's another way you can charge royalties. So there are different revenue sharing agreements that you can also do, right? Depending on the industry that you are. For many people that collaborate in companies, maybe you decide to come together with somebody and then you create a company, and then your most valuable stuff is an IP asset. I mean, your selling point is an IP asset. Let's say you create a software or all of that, which is basically copyright. So then it's equity based. That means that your share capital, how much capital contribution you have. Then there's also sponsorship. MTN sponsors you on a project, right? All of that. They claim revenue from, let's say they sponsor a show, right? And then there's an IP involved. In fact, there are usually so many IP assets involved. So there's a revenue sharing formula, 60-40, 70-30, how much. And I know for many people, music industry lawyers here must have come across what is the split sheet. Let me just dwell on this for like 2 minutes. A split sheet is basically an agreement for songwriters. Let's say, who can give me the name of? Okay, let's say Ashake and Fireboy DML. They want to sing a song. They want to sing a song about me. About that, I'm going to be the biggest lawyer in Nigeria, right? They'll sing a song about me, and then they create a split sheet and say, okay, this song, not only them, right? Let's say they now bring not DJ YQ, Cleverly, or they bring which other DJ that is going to come and make the Neptune. Yeah, Neptune is the one that creates this. So there's a split sheet. Neptune says, okay, I'm going to take 20% from this. They get a drummer. Drummer says, I'm going to take 2%. Fireboy DML says, oh, I'm a big guy on this place. I'm going to take 30%. Ashake says, I'm the new boss in town. I'm going to take 45%. So a split sheet is like an agreement that shows the percentage you own in the copyright and how much you would be getting at the end of the day, let's say for streaming, broadcast, and they're also collective management organizations where you can also license them to help you collect royalties and all of that. So a split sheet is like an agreement, a revenue sharing agreement for that sake. I think I'm at the end. Okay, so emerging trends to watch out for in licensing. Number one, streaming and streaming services will become explosive. As you would have seen, Netflix has grown over the years. There has been like a year-on-year increase of above 7%, year-on-year. So that is like steady increase. So there's going to be an increase in demand for gaming licenses. We already saw in 2022 there was The Witcher. I'm giving this example of the Brotherhood. I'm sure some of us have heard of that movie that was done in Nigeria, Files and all of them. Yeah, so let's say there's a company in Nigeria that wants to take on the gaming license. So that's licensing for. So under those rights, okay, let me just do this last one. What's the time? Okay, my time is up. I just want to say, like, for instance, now, a gaming license, under which rights do you think it will fall under? If we go back here, under which rights do you think it's going to fall under? A gaming license. Let's say somebody wants to make The Brotherhood into a movie, or Tom Cruise Mission Impossible into a game, rather. What rights do you think is going to fall under? Of course, it's going to fall under adaptation. Let me just move on so that I can take questions. So again, there will be more mechanical license organizations. What are mechanical license organizations? In the US, for instance, they have what they call a mechanical license organization. That is all artists, all your rights, right? It's like in a big box. Yeah, you're right. You're right, adaptation. So it's like in a big box. So anybody that wants to use your rights, let's say in a movie, your music rights in the movie, they want to use it to produce a movie. Let's say they want to do, what movie in Nigeria is popular? I'm thinking. Let's say Kule Afolayan wants to produce a movie in Nigeria and wants to use a US rapper's song, right? So it goes to that licensing organization, mechanical licensing organization, tells them the bits of the track that he wants to use. Let's say he wants to use 1 minute of that track in his movie. So they tell him how much, they negotiate on behalf of the artist. So when they negotiate like that, so they take their commission and then remit the rest to the artist. So so let's say like there are like hundreds of thousands of artists in America, yeah. So they help them to manage those rights so that it's also easy for, let's say, movie producers like Kule Afolayan. They don't have to go and meet all the artists. They can just go to the licensing organization, take the music that they want to use, pay it off using their credit card, use it in their movie, and everybody gets settled. So smart contracts will also be implemented for franchises. I don't mean to confuse you here, but this is the next gen technology. There will be smart contracts. Smart contracts, they are self-executing contracts on blockchain, decentralized finance. Don't worry, let me not speak too much gibberish. So it will be used for supply chain, for collection of royalties, and so on and so forth. All right, so let's say, for instance, now, instead of KFC having to, invoice the franchisees in Nigeria, let's say, oh, you have to pay me $100 million this year for all of the sales you made. Instead of just going through that route of invoicing, if they execute a smart contract on their supply chain, so for every sale they make, right, it's already deducting it. So at the end of the year, automatically it's remitted. Nobody can change it. It's on the blockchain network. So we'll see more of that as we go on in 2023 and 2024. That's the next gen stuff. So questions. I hope I was not too fast. Thank you.
Definitely not. You've actually done justice to the topic. I really appreciate that you've given us in-depth analysis of licensing and everything that it entails in Nigeria. I really, really appreciate that. Thank you very much. So please, if you have questions, kindly drop them in the chat box. And if you'd like to speak up, you can request the mic so you get the mic and you ask your questions. Thank you very much.
Thank you too.
But personally, I have a question. I don't know. I actually have issues with my networks. I don't know if you've addressed it while I was offline. And it's about when I saw the list of the licensing you said we have in Nigeria, you said exclusive, non-exclusive, the sole licensing. Now, I've read about licensing, and one of the major things, two of the major types of license that I've seen is synchronization license and a mechanical license. Now, would you is it that these two other licenses are subsumed under the 4 licenses you've explained, or I don't really know why they are not part of the licenses you mentioned, sir?
Yes, synchronization license is basically the one that I explained about Kulia Folayan, mechanical license. It's a bit of both, right? Synchronization license is that which music producers or executive producers, they go to get your movie, get your songs, then they synchronize it into their movie, or let's say a music video, all of those things and all of that, let's say a speech or whatever. So yes, it's subsumed under non-exclusive license because the license they are giving to you, they can give to somebody else. It's non-exclusive. So it's just like it follows under, how would I say it? It's a form of it. It's a form of non-exclusive license because the same rights they give to you, right? They can give to another person because it's usually managed. Synchronization licenses, mechanical licenses, they're usually managed by mechanical license organizations or collective management organizations. We have the MCSN in Nigeria, Musical Copyright Society of Nigeria. So basically, they help you manage those licenses and it's a non-exclusive license. So that means that if Kulia Folayan comes, Ebony Life comes, for the same thing, they will give to them, right? And that's it, they'll give to them. So unless there's an agreement that is now reached between you and the executive producer, and then it says that please do not license this part of the music track to any other film production house in Nigeria or in the world, that is when it now becomes what? An exclusive license. But as at the point where you're just contracting is simply a non-exclusive license. I hope that clears it up.
Yes, definitely, sir. Thank you very much for the answer, sir. Thank you very much. We really appreciate you. So in the absence of any other question, in a very special way, I would like to thank everyone who has made it to this event, to this IP annual discourse. It's really been an eventful and interesting ride. I really appreciate, and on behalf of the IP convener, of this discourse convener, person of Ms. Oloni, we'll say a very big thank you to all the facilitators, all the speakers, and everyone who has come to spend their time with us, exchanging ideas and everything. Thank you so much. But before we actually close, I have a little bit of an announcement to make here. And for those who will be interested in participating in this, there will be an avenue for you to be a part of the IP team. So this is basically for content for announcement, which join the formidable team of IP Business Capital. So we are looking for young and vibrant IP enthusiasts to join the team. So if you'd like to volunteer and be a part of our growing team, please visit the link. So I think the convener has been constantly sending the link into the chat box thing. So you can just go to the chat box now, then click on the link. Or generally, you can just visit the website of the IP Business Capital, that's ipbusinesscapital.org. So from there, you get the link to register and be a part of the IP team. So secondly, we have the African Creative Hub. So if you are a creative in the film industry, now here is an open call to join the African Creative Hub. The African Creative Hub is a premier hub for African storytellers to develop hands-on practical skills to grow their capacity to tell stories that travel around the globe. So as members of the hub, you have access to the following: entertainment events, screenwriting masterclass, filmmaking masterclass, networking and collaboration opportunities. So a lot of opportunities for you in as much as you are interested in intellectual property. And of course, guess what? It is free to join the platform, but strictly for screenwriters, filmmakers, and creatives producers. So once you fall into any of these categories, you can easily apply. And again, check the chat box. You will see the link to apply for this particular opportunity. And lastly, which is the platform for young professional program. Now, our young professional program is coming up soon. It is a program for young Africans looking forward to building careers in the field of intellectual property management. The objective of the program is to bridge the skill and knowledge gap required to develop the intellectual property market in Africa by mentoring and training young high-pay professionals across Africa. And again, the link to apply for this is already in the chat box. So in a very special, I want to say thank you again for everyone who has joined us. Thank you very much. And we hopefully think that probably by next year, when this particular discourse is going to come up again, all our facilitators will be, obliged to accepting our request, our invitation to come and be a speaker in this discourse again. Thank you very much. Thank you very much. Thank you. Have yourself a lovely evening. Thank you. Take care.